Yes.
Yeah. But there is one matter.
Oh,
I asked him whether there is any judgment to be pronounced.
oh, not today.
Item number 19, my lord. I appear in the case petitioner. There was some connected matter where my learned friend is here. I requested because we want to withdraw with the liberty to file. A freshness because there was subsequent events against this.
Okay.
19. But rest is, I am there, but rest we are not required. Only in respect of item number 19. I call up the Mr. Chakraborty also.
Right, Mr. D. Das, senior counsel, submits upon instructions that he has been given instructions to withdraw the writ petition with liberty to file.
Yes.
Mr. Engineer Chaudhary, senior counsel for
Going this one.
ONGC.
All the rest.
Appeals for all those. The prayer of the petitioner's counsel is allowed, the petition is dismissed and withdrawn, with liberty and appeal. What about 2021? What to
No,
do?
in that item number 20, apparently an IA has been filed day before yesterday.
Item 20, item the petition. I filed an IA.
It's not here.
No, it has perhaps been listed. It is not there,
Listed.
but it has been filed only day before yesterday.
Ah,
So we'll be needing some time to take instructions.
IA for what?
This for bringing on record certain documents.
Right, in this item 20, you're right. Mr. R.B. Fukan appears for the writ petitioner / applicant. And prays that certain documents need to be annexed. Needs to be brought on record.
Needs to be called for.
Needs to be called for from where?
From ONGC.
Needs to be called for from the ONGC. Mr. I. Chaudhary appearing for the ONGC is granted.
For some about 10 days time. to take
Granted,
instruction.
granted 2 weeks time to obtain instruction. List the matter between.
And the other matter 21 can be listed along with item 20.
I appear for 21.
So list this matter along with.
Yes.
It's already there. It's already together.
I think
Is there
in the main petition also the replies have not yet come.
There also we need at least 2 weeks.
okay,
time to file.
Mr. Engineer Chaudhary also submits that in the IA only, huh? That means that he will be filing affidavit in a position in WPC 1080/2025 within 2 weeks. Then what about item 21?
21 also we are required to file our counter.
Okay, right. Right. In 1080/25 and 1230/25.
Ah.
And 1230/2025.
Deeply updated.
Can a date be fixed, man? That way it will be
When?
26th or 28th of 28th of May.
28th, okay. On the prayer of the parties, list the matter on 28th May.
Deeply updated.
May I please, Your Lordship? I'm praying for listing of these 2 registrations on Tuesday, Lordship.
Matter relates to?
It's related to fresh noted by the respondents without considering the order of this honorable court that the earlier contractor was awarded 2 full term. So we have an interim, Lordship, and it was fixed yesterday.
Okay.
Make clear, Lordship. I am praying for listing of this matter tomorrow, my lord. Tomorrow, my lord, in a sense, my lord, we have my lord meat parlor in a different my lord railway station under the my lord Lumbering Railway Union. And
Partner?
meat parlor, my lord. Milk stall.
Oh, okay, milk stall. Well, what is the term you used just now?
Parlor, my lord.
Huh?
Parlor.
Parlor. Oh, parlor. Okay,
My
milk
lord,
parlor.
what happened, we have my lord running this stall since 2013, my lord, under the policy, my lord.
2010 policy.
Yes, my lord. Then, my lord, now, my lord, and according to the my lord Supreme Court, my lord order. My lord.
Now, no extension.
Yes, my lord,
Then-
they have now led issued for my lord petition of rules, my lord.
Okay,
Yes,
okay, listen, wait, tomorrow, okay, tomorrow. But you've got a steep hill to climb. I don't know whether you'll reach the top. 2017 regulation has been upheld by the Supreme Court. The catering policy, I mean, catering policy of 2017, correct?
Yes, my lord, we have the minor needs, my lord. All are the minor.
Maybe, but in the, you cannot ask for extension in terms of the catering policy of 2010, that is gone. That's gone, and And there was an exception only to the extent that if the extension had been given at the time the 2000 policy was valid, and after the 2017 catering policy came into effect, then that period of extension would be allowed. But beyond that, it cannot be allowed anymore. It's decided by single bench, in fact, by this court, by the division bench, upheld by Supreme Court. Very difficult for you. And
Okay. May I make to mention item number 8, madam?
like
Complied.
8 is complied with.
Madam.
Okay, right. Mr. A.K. Hussain, learned counsel for the petitioner, submits that the contempt petition can be closed as the petitioner's representation has been decided. So, sir, enjoy the submission made by Mr. A.K. Hussain, the contempt petition stands closed.
Here I am praying for continue for arrested of this matter, not and arrested for what reason is not. Learning this way, as for the penalty may not within the time specific period, I have submitted my bid, along with my arrest, post with pardon may not. And the last date fixed on 1st of April may not. And thereafter, we have not received any intimation from the authority despite we made the representation as well as legal notice today. But we have recently came to know by today or tomorrow, we have within these 2 days, they are going to open the bid without my participation. So some arguments is there, not. If lordship arguments today or tomorrow, give them.
May I please, your lordship, I beg to mention item number 15 and 16.
Huh?
I beg to mention item number 15 and 16, lordship.
15 and 16.
Yes, I have taken consent from the other side, and we are newly engaged in this matter. This is why we need 1 week time to proceed with the case, lordship.
Let's stay is there, madam. So let me on my next 15 madam, next week, madam.
Yes, please.
Let no contextual matter, madam.
All right,
15.
adjournment prayer has been made by Mr.
R. Hawk, my,
R?
not R. Hawk, lordship,
R. Hawk,
lordship.
learned, who submits that he has been recently engaged
Yes, lordship.
by the petitioners, by the writ petitioners. By the writ petitioner.
Yes, lordship.
Have you submitted Wakalat Nama?
As per instruction given by my senior, we have submitted to Wagala.
Let us see the records, if it is there or not. You see, because the problem is sometimes Wakalat Nama is not submitted. When did you file? As per your instructions?
This,
No idea.
I do not have idea. Today morning I have instructed by lordship.
Who is the, huh?
Earlier council I told yesterday, not, he's, so give no option certificate.
He gave no writ.
Yes.
No, I'm not on that. I just want whether the Wakalat Nama has been filed.
I may be wrong, lordship. If I have not submitted the Wagalatnama, we will file it today.
Okay, right. He submits that. If Wakalat Nama has not been signed, has not been filed, the same will be filed within the course of the day.
Lordship.
He prays that the matter may be listed on where?
15 madam.
15.
Lordship.
Mr. 15, this is the matter of 15.
My name is record.
Mr. S.K. Mehdi, just say he and Mr. S.K. Mehdi, let's see, he prays that the matter may be heard on 15, this is the matter of 15.
Lordship. Yeah, please, your lordship. Which I think to mention to extend motion matters, lordship. Matter pertaining to suspension of mining operation, lordship. Lordship is to the disposal of these matters, lordship. Lordship may principle.
Acha, those review matters
Yes, lordship.
before the
Yes.
case,
Yes, lordship. Tomorrow.
similar matter,
Similar.
similar order.
Yes, lordship.
Okay.
Tomorrow.
Tomorrow.
Great, please, your lordship. Today, more than 2 years, 6 months behind the bar.
Huh?
More than 2 years, 6 months behind the
So,
bar.
not enough.
Lordship,
You can be in jail for how long? 20 years.
lordship, new ground has been.
What is the new ground?
Lordship. Kindly peruse page 35, lordship.
That we find.
No ground of arrest mentioned in the notice, lordship. As well as the arrest memo, lordship, in page number 36, lordship.
Huh? Yes. You are relying upon that
Lordship,
PMLA judgment
Lordship,
of the Supreme Court.
Lordship, two judgment Lordship, one is
Yeah.
Vihan Kumar and another is Kavi Pukaresto Lordship. And second. ground-
Basically, he's saying
Yes, and
that there's a difference between grounds of arrest and reasons for arrest.
in Vihan Kumar, it says that the grounds of arrest will be provided in writing.
Correct.
Initially, because if Pankaj comes up, then Kavi Pukaresto, then Vihan. So regarding those aspects, I'd like to argue on the sort
Ah,
of,
okay.
yeah, scan copy may be called for.
Scanned copy of the
LCR.
SCR. It's only the issue of arrest memo is required. That's the only issue.
Yes, Lordship,
His only case is with regard to his arrest.
Lordship.
So won't arrest memo be enough?
enough,
Huh?
enough.
You bring it, you
I
bring
think
it.
it also became the ground of following the series.
Lordship.
So in that respect, scan copy is required
Scanned copy of
of the LCR.
SCR required.
Yes, basically my learned friend has taken 2 points.
Why didn't you annex the LCR copy?
Lordship,
Yeah,
I have annexed the order.
you have got so much money, or you have been at least charged with such a huge
Lordship,
case.
I have annexed last order, Lordship, at page 33, Lordship, kindly peruse, Lordship.
No, why didn't you annex the LCR yourself? Your client is supposed to be involved in a very serious case. How many? 1 kg?
Lordship.
How much? Half kg. Half kg is big enough.
Kindly peruse the order at the Lordship, C 26-3, Lordship.
You produce the LCR.
Lordship, they will,
Why?
record may be called for, Lordship.
Okay, we'll give enough time, right? How much time? After 4 weeks?
Any day, Lordship.
And it's the
Keyboard, Lordship.
Board of Learned Counsel for the petitioner who submits that. The petitioner should be released on bail. Inasmuch as the grounds of arrest have not been given to the petitioner in writing at the time of his arrest.
Round of
Huh?
As well as that round of prolonged incarceration.
Is that required? Is that required? When charge sheet has been filed?
Charge sheet file, charge not yet filed, Lordship, 2 years, 6 months.
Maybe that is the fault of the court, not of the fault of the enforcement agency. Right. Issue notice returnable in how much? 4 weeks or 3 weeks? 2 weeks.
Lordship, yeah, Kamru Metro.
2 weeks. 2 weeks. 2 weeks. Mr.
RR portion.
R. Kaushik, PP,
It's a
additional PP, accepts notice on behalf of the state. This is the matter. After 2 weeks to enable the PP to enable the PP to produce the
Lordship, usually the scan copies all by the registry only.
okay. To produce the case diary. Further. The scanned copy of the LCR may be called. Or of the charge sheet be called for from.
Scan copy of the LCR.
Scan copy of the LCR be called for from the court of the
Special Judge NDPS Kamru Metro.
special judge NDPS Kamrup Metro.
Guwahati, Lordship.
Guwahati. This is a matter after 2 weeks.
Oblige.
They're supposed to play the written instruction.
Proposal has been sent to the government locate.
Government, not to and the government has sent it to the finance or what?
Not finance to the government
To
locate.
the government.
That's my number 2. Fortunately.
Mr. Buyan, your submission on the last day was that financial sanction had been sought for from the finance department.
You also said that the lordship makes certain corrections in the order. Just so corrections will not make.
So the directorate has sent it to the government, correct?
Yes,
Now the government has to send the proposal to the finance department for sanction.
that will take some time.
Why? Sending a proposal will take how much time?
Lordship takes the matter.
You see, I can understand if consideration of the matter takes some time. But acting as a post office should not take time. The issue with regard to verification of the bills is the job of the directorate. The job of the secretariat is only to see that the procedure has been followed and forward it to the finance department, that's all. Huh?
Lordship was necessary orders.
No, I'm not passing necessary orders. The only thing I'm asking you to send the proposal to the finance department. And on the next date, the proposal, the forwarding letter sent by the secretariat to the finance department should be put before this court. Okay. All right. Ms. D. Bora, the learned counsel for the
Health department.
health department submits that the Directorate of Health Services, bracket FW, comma, Assam, has submitted the proposal for financial sanction amounting to rupees 19,98,079. It is payable to the petitioner, to the additional secretary to the government of Assam, comma, Health and Family Welfare Department, by letter dated 6/5/2025. Next paragraph. The said letter dated 6/5/2025 is made a part of the record and marked as an XAX. Oh. Next paragraph. List the matter on when can you bring the said letter? Today is? List the matter on 22. 22/5/2025. On the said date, Ms. G. Bora shall produce the letter sent by the Secretariat of the Health and Family Welfare Department to the Finance Department seeking financial sanction and approval of the amount payable to the petitioner. This is the matter.
Yeah, all of this matter, actually, I was miscommunicated. This petitioner, my lord, it appears, my lord, he is selling, my lord, beef also, my lord, in his shop.
Huh?
He is selling beef also in his shop. And for the purpose of selling beef, my lord, these certificate, this license which he has, that will not do because now with the Cattle Preservation Act in force, my lord, a special license is required, my lord. Anyway, my lord, it may be disposed of with the direction that, my lord, I'll apply for a license, my lord, will consider as per law, and they will give me the permission and I'll continue with my license. Whether this shop is not closed, Malati is still running.
Okay, it's
It's setting up a meat lock. No, not at all. Not like that is Malati. That may be taken. I have taken my.
No, so it's okay. If he says that it is open, then we'll say that in terms of his statement, it should be open. That's all.
Last week, the Malati complaint.
This letter that we have mentioned from the additional district magistrate to the circle officer. The date is not given, only month and year given.
Hello, sir.
This is not relevant, I think.
Not it.
Right.
After to that, my lord, that complaint filed by the one person.
According to you, the shop is still open. So let him continue.
Okay.
And if he wants to sell beef, let him apply.
Yeah.
And until he gets the permission, he will not sell. That's all.
Yeah.
Heard Mr. G. Chaudhary, learned counsel for the petitioner. And Mr. J. Handit, learned counsel for
Report number 2, Lord.
two, report number 2. Who appears for the others? What about State of Assam Commissioner Panchayat, Mr. S. Datta? Mr. S. Datta appears for respondent number 1. No one appears for the respondent number 3. Has no notice was issued to the respondent number 2. Stop. Right. The petitioner's case is that he is the owner of a licensed meat shop within the jurisdiction of the Dolabari Gan Panchayat in the district of Sonitpur. Where is your shop license number?
My lord, that your lordship finds at page, my lord. Page 10, my lord. License number, my lord, 139 dated 1/7/2023.
Where?
The last page, page number 10.
Ha. Where?
72 on top left, my lord. Top left, my lord.
Having DGP number,
My lord.
comma, having DGP number 72/2023-24/72/20, no, again it's
No, my lord, that's 139.
72/2023-24/139. But this is 23-24 only.
Thereafter, if your lordship comes to the bottom, my lord,
Ah,
that serial number.
okay, dated 1/7/23,
Yes,
which was renewed up to 31st June 2025.
my lord.
What's that? The petitioner's grievance is that while the petitioner was running his meat shop peacefully and in compliance with all the norms and regulations, some officials, you take this para, the last order, para 1, para 2. No, para 2. Next. Mr. J. Hendrick, learned counsel for the respondent number 2, had been asked to obtain instructions with regard to the closure of the petitioner's meat shop on the spot date. Pushpa. Next para. Mr. J. Hendrick, learned counsel for the respondent number 2, submits that he has received instructions to the effect that the petitioner's meat shop has not been closed by the official respondents and that the petitioner's shop had been visited by the officials due to a complaint having been received that the petitioner was selling beef in his meat shop without having proper license for selling beef.
Complaint filed by the one, Abdul Noor, the student of.
First up, in this respect, a complaint filed by one,
Abdul Noor, student of Durham College.
where is that?
Already the last case of this.
Okay, one, Abdul Noor, ABDULNOR, student of Darang College. Okay. First up, he submits that the selling of beef without a license is in violation of the Assam Cattle Preservation Act 2021. And as such, the petitioner cannot be allowed to sell beef without having a license for the same. Full stop. Next. On hearing the counsels for the parties and keeping in view the submission made by Mr. J. Handik, learned counsel for the respondent number 2, that the petitioner's shop is still open and he can be allowed to sell meat as per his license, except for beef. This court is of the view that the writ petition can be disposed of at the motion stage itself. First up, accordingly, the petitioner should be allowed to run his shop in terms of his license. First up, however, he shall not sell any beef or beef products in his shop without first obtaining a license for the same in terms of the Assam Cattle Preservation Act 2021. Correct?
Lord.
That's all. The writ petition is accordingly.
He will apply what that will be considered within a fixed time.
First stop. First stop. In the event the petitioner applies for selling beef, the respondent shall consider the same and take a decision at the earliest.
And even in a paragraph number 4 also. Let's see, the shop of the petitioner within the 5 kilometer radius.
At the earliest, and in terms of the Assam Cattle Preservation Act 2020. The writ petition is accordingly disposed. I don't think you are really bothered with that beef part. You are bothered with the closure. No, that's it. The writ petition is accordingly disposed of.
Okay.
That petition, it's my lord.
Yes, what to do?
She will find.
Notice. Supply bills. Heard, mister?
That's not.
As not learned counsel for the petitioner who submits that the petitioner supply bills amounting to 22,97,797 have not been paid. Issue notice returnable in 4 weeks. Mr. B. Chaudhary accepts notice on behalf of
Lordship, 2 and 5.
2 and 5. Mr. M. Chettiar accepts notice on behalf of
1
1, 3 and 4. This is the matter after 4 weeks to enable the respondents to pay instructions and file affidavit.
This is the maybe taken after some time. Mr. R. Gogoi, we supposed to appear on next.
Yes.
Lordship, the matter pertains to non-payment of vehicle hire charges from Lordship March 21.
Yes.
This one is a fair exchange.
Affidavit. What is the affidavit? say?
Admitted amount, my lord.
Huh? Admitted.
Lordship, they admitted, but Lordship, there is a small thing. Before we file the writ petition, we prefer the RTI. In the RTI, a certain amount was given, but Lordship, in the affidavit, it's a different amount. Lordship,
You see, we cannot go into those issues. You can go into
it's about
civil.
higher Lordship.
Huh?
What they've admitted is a higher amount.
So it's okay, good for you.
Lordship.
We'll
But
go
again,
by,
Lordship,
we'll go by the affidavit.
Lordship, there are two contradicting figures in the affidavit. Lordship,
Oh.
it can be a para 6, Lordship, I point out. Lordship.
Affidavit or response number 4 and 5.
Point number 3, Lordship.
3. Yes,
Starting page 86, Lordship.
yes,
Para 6, Mary, Lordship.
yes.
Sir, with regard to the statement made in paragraph 5 of the writ petition, the answering deponent respectfully states that there is a pending liability for an amount of rupees 2 crore 66 lakhs 56,930. Only as expenditure incurred for providing logistic support to the army, CAPF deployed to Gwalior district for conducting counter-insurgency its operation with effect from April 2021 to March 2022, and rupees so and so only for the period of April 2022 to September 2022, and demand of which was submitted to the government by this letter or by this office letter number so and so dated so and so, and so and so dated so and so. Now, Lordship, important part. For hiring charge of the vehicle and amount of rupees 36,62,220 is pending liability of the vehicle hiring charges for the period of April 2021 to March 2022, and Lordship, rupees 17,41,248 only is pending liability of the vehicle hiring charges for the period from April 22 to September 2022. This is including the demand proposals mentioned above, which were submitted to the Additional Secretary to the Government of Assam, Women Political Department, and the Joint Secretary. Now, Lordship, in the 7th paragraph, Lordship, they're saying that with regards to the statement made in paragraph 6 of the petition, it is to be mentioned that after releasing the state vehicle registration number so and so, in the name of which is the name of the petitioner, all pending liability expenditure incurred for the council institutes operation in Gwalior district were submitted to the Women Political Department from time to time in form of demand proposal of funds by the DC Gwalior by letter so and so. Now, Lordship, para 8. That with regards to the statement made, paragraph 7, the petitioner answering respondent respectfully states that the payment of the pending liabilities against the vehicle hiring charges of the vehicle paying registration number so and so, owned by the petition amounting to 12,05,874. So, Lordship, there is a contradiction in their claim itself. Once they are saying 33 lakhs, 62,220. On the other hand, they are saying 12,05,874.
No, one they're saying 36 lakh
Lordship.
and the other is for 17. So altogether would be how much? 53, 54,
54 almost.
54, 54 lakhs.
Lordship.
For 54 lakhs, and now they're saying 12 lakhs.
Lordship, on the next.
And your bill is for?
Lordship, my bill is, Lordship, I have preferred a RTI. In the RTI,
RTI how much?
RTI reply, Lordship, they have replied 12,05,874.
So this is 12 lakhs.
But Lordship, the problem is that, Lordship, the rate.
Now
that has
you
been-
see, how much is your claim?
Lordship, my claim is only from March 21 to May 23.
How much? I'm not saying the period, I'm saying the amount.
Lordship, I have not claimed any amount.
You don't know how much
there
you
is a-
claim.
Lordship, there is a rate as to which the vehicles are to be paid.
You see, Mr. Kaushal, you're a businessman.
Lordship.
I'm quite sure you calculate the amount you have to receive.
Lordship.
On some days, they might use it for 10 hours, in some days they might use it for 8 hours.
Lordship.
So it's a difference.
Lordship.
Now, if you don't know the amount
Lordship,
you're
may I
supposed to
submit the
get,
rate, Lordship, that will be fixed by the government, Lordship. Lordship,
I'm
the
not
direct
going-
one thing
I'm-
after verification.
you go to the
Lordship,
civil court.
Lordship, what after direction, Lordship, whatever, after verification, Lordship, in line with the commercial, Lordship, whatever we are due for that, we may be paid.
Yes,
Yes, sir.
but what is to be done? How come we have got two rates? Page para 6 and para 8 is different.
Maybe, sir.
Huh?
It depends.
You see, para
But in
Para 8 does not-
This is specific.
Huh?
Yeah, 8 and 9, it is specific matter because it is 12 lakhs. That problem.
but you have not given the period.
Lordship, may kindly have a peruse instruction that will perhaps draw a clearer picture.
Huh?
Lordship, may kindly peruse the instruction that will perhaps draw a clearer picture.
No, I think it'll be the same thing. I don't think they will change it. Or we can ask them to clarify,
Lordship. As per Lordship.
clarify whether 6 or 8 will be the correct amount paid to the petition. Right. Have Mr. F. Mitra, learned counsel for the petition, and Mr. M. Peter, learned counsel for?
Matter 2, 3, 4, 5. Let's see. Not 5.
2 to 5.
No, not 5. 2, 3, madam. 2 and 3, madam.
2 and 3.
2 and 3 and 7.
2, 3 and
7.
7. Mr. M. Buyan appears for? That point number 3. Right. The petitioner has paid for payment of his vehicle hire charges. The affidavit of the respondent number 3 is to the effect that the petitioner is liable to be paid vehicle hire charges amounting to rupees 36,62,220 for the period from April 2021 to March 2020. And rupees 17,41,248 for the period from April 2022 to September 2020. Thereby coming to a total amount of rupees 54 lakhs approximate. On the other hand, para 8 of the affidavit filed by the respondent number 3, para 8 and 9 shows that the respondent number 3 has admitted that the petitioner's outstanding amount is rupees 12,05,874. Next para, Mr. M. Catering shall obtain instruction as to whether para 6 or para 8 and 9 have to be followed in deciding the outstanding due payable by the respondent to the petition. List the matter on when? Huh? What? List the matter on 22. 22/5.
What is it? This is the respondent.
Item?
Item 5. Respondents have filed their affidavit in opposition. They will one week more time for filing affidavit in reply.
Mr.
AA.
Huh?
AA.
AA? Ahmed. Let counsel for the petitioner is granted.
1 week.
Huh?
1 week.
1 week time to file affidavit in reply.
Must
Just a
be
minute.
for interim may be considered on the next week.
Well, Lordship, we have filed our affidavit in opposition raising issue on the maintainability of the writ petition. That has to be decided first before the interim.
Okay, so what is the issue? What is the case about?
Lordship, the respondent, they have floated a tender. They have participated and they have disqualified us on a vague ground.
Disqualified you.
Disqualified on a vague ground.
Vague ground. What is the vague ground?
I will get page number 44. But it.
Yeah.
1.6 earnest money deposit.
Yes.
Page number 45 project for preparation of fixed deposit receipt only. Name of beneficiary Hindustan Steelworks Construction Limited. Bank so and so. Lordship, we have deposited the earnest money, but they are saying that we have not deposited in their favor. Lordship, may kindly have a look
In
at-
there?
They have rejected my tender on the ground that I have not deposited the earnest money in the form of.
So what is wrong with that?
Lordship, that is the issue, Lordship.
If you have been asked to deposit earnest money and you have not
We have
deposited,
deposited, Lordship.
you
That is-
deposited,
that-
but you have not deposited as per the format.
It's their allegation.
Huh?
Yes, Lord.
So what is wrong?
Lordship, it's their allegation, but we have submitted and it is in the proper form. Lordship, may I have a look at page number 135, Lordship.
135. Yes, 135.
Lordship, earnest money deposited in the form of bank deposit. Hindustan Steel Works Construction Limited. It's in their favor.
Hindustan Steelworks Construction Limited, yeah. Then, what is this Meghalaya? Meghalaya Construction Supply Company, what is this?
Petitioner.
Petition. Through online gateway or in the form of bank guarantee. So you have submitted in the form of fixed deposit.
Yes, Lordship. There are three modes of submitting. I have submitted in the mode of fixed deposit.
Have they asked you have they asked the bidders to submit it in a, by way of a fixed deposit?
Lordship, there is a provision. There are three modes of submitting the earnest money.
Let us see,
Three modes. Lordship, that was that I was showing.
page
on number
144.
44, Lordship. 1.6, Lordship.
Yeah,
Earnest money.
yeah.
A for online e-payment gateway only, B for preparation of bank guarantee only, and C is for preparation of fixed deposit receipt only.
Okay. Fixed deposit receipt.
Yes, Lord.
Yes,
Lordship, kindly have a look on page number 449 of Annexure D.
who are you?
I'm Sir Lordship, I'm appearing for respondent and I'm Deputy General Manager Law.
Respondent, what respondent?
One.
You have got a council.
Yes.
Why you don't believe in a council?
I believe in my counsel, Your
Then
Lordship.
why should I hear you?
Few facts I want to place on record myself.
Your counsel is there. Either you do away with your council or the council should be heard.
My counsel. I'll assist.
You can assist your council. Yes, which page?
449.
In receipt of FDR number 3865130021 and 5, dated 14/1/2012.
Which page?
449. Yeah.
Four four nine, yes.
It's an email from the bank
Yes,
where we have sent that FDR number so and so dated 14/1/2025 of rupees 11,82,692 with maturity dated on behalf of Meghalaya Construction Supply in favor of Hindustan Steel Corporation Limited for your ICICI Bank Limited, Nagaland, against which confirmation is required regarding you are pleased to confirm the issuance. In reply of that mail, the bank has replied that FD number so and so has been issued, that so and so.
where is the reply?
Sir, under this, March 27, that email
Yes,
sent on 5/35. FD number 3865 and so has been issued on the date 14/1/2025. The maturity that will be 14/1/2026. The same has been marked lien with the mark of NOC required for SSCL. That is the issue, Your Honor. You need to provide.
also encashment letter needs to be provided by the Meghalaya Construction Supply Company.
Yes.
And NOC needs to be given by HSCL. HSCL is you
Yes.
for closure. So you cannot encash it.
Yes, madam, that is the.
It has to be encashed by him.
Yes, sir.
What is
Lordship,
it?
I have a look at page number 72, Lordship.
Huh?
Lordship, I have a look at page number 72. The rate petition.
Just page 72.
72, annexure 5.
Yes.
Lordship, serial number 2, Mrs. Meghalaya Construction and Supply Company. Lordship, they are disqualified due to non-submission of valid EMD, FDR against EMD, not lien marked in favor of Hindustan Steelworks Construction, which was not complied with as per NIT clause. They simply mentioned the clauses. They are not specifically mentioned that why it has not been accepted.
No, you see, when they cannot encash it, what is the purpose of earnest money? What is the purpose for submitting an earnest money? Have you any idea? No.
Fortunately, I think maybe one big time I'll place all the
No.
on my reply.
When you don't even know the purpose of submitting an earnest money in the first instance, what are you going to explain? You've got to know the meaning. Why is the earnest money deposited by a tenderer?
For security purpose.
Huh?
For security purpose.
For security purposes. Then, if he cannot encash it, in the event of you, in the event of you not complying with any of the terms and conditions, then what will happen to him? He cannot encash it.
Actually, we have complied, Lordship. We have complied as per
You have
clause.
complied with what?
We have complied.
No, Mr. Counsel. You see, the bank guarantee can always be encashed. Okay? You cannot stop. But here, he cannot encash it. Supposing he wants to encash it for a supposed fault done by you, he cannot do it. So the purpose of this earnest money is of no use.
That's what I'm doing. There is no fault on my part, Lordship. We have
For
submitted the earnest
preparation of it.
money as per the tender clause, Lordship.
But then on the other hand, you have asked for a fixed deposit. Then,
Lordship, kindly have a look on page number 431. Clause 4. The Roman,
431, yes?
Roman clause 5, Lordship.
Yes.
EMD may be forfeited if the bidder withdraws the bid after bid opening during the period of validity. Yes, B is any unilateral revision in the offer may be by the tenderer during the validity of the offer.
No, this is all right. This is all right. You see, but the problem is you have asked for a fixed deposit.
But Lordship, I'm not denying it. I want the FDR in form of EMD. EMD in form of FDR, Your Lordship. The FDR, the essence of the EMD was not followed by the petitioner here, Your Lordship. Because if my interest in case of default, the petitioner default, Your Lordship, if I cannot encash it, then the purpose is defeated, Your Lordship.
But can there be a FDR?
Lordship, it is.
Can there be an FDR which can be encashed by you?
Lordship,
There can be.
yes.
Show me.
It is there, Lordship, the EMD we have mentioned, sir. It is part of EMD. EMD may be submitted in three forms. One is FDR, second is form of bank guarantee, the other is.
So he has submitted as per FDR. So what is
But
wrong?
Lordship, the condition number 4 is not followed. Your Lordship.
Condition number
I-
4? Which
Condition,
condition?
431 page number. What he was reading out, Your Lordship. And Lord,
431. 431. 431. Condition number 5. Why?
the EMD may be forfeited if the bidder withdraws the bid after bid opening during the period of validity,
I'm not on that. The issue is this, and I don't know why you are arguing also, you got a counselor. The issue is this, can there, how many types of fixed deposits are there? A fixed deposit, when it's made, if it's made in your name, then why should you have the right to encash it? You should be having the right to encash.
yes, because it is.
If the fixed deposit is in his name, why should you have the right to encash?
No, lordship, it should be marked in lien. Actually, it
Marked,
is in their name only.
Where?
The bank has already confirmed your lordship.
Where
Bank
page,
will
page,
take it into
page,
consideration for this.
page
Bank, page.
449 or what?
Yes, four. My interest is not protected.
Where does it say it's in their name? We are in receipt of FDI in favor of, it's in favor of MS Hindustan Steelworks.
But lordship, the bank has confirmed, if we cannot encash it, what? And it can be,
No, FDS has been issued on so and the maturity will be, and the same has been marked lien with remarks NOC required from HSCL. Has been marked lien means what?
lien means it cannot be encashed by either party.
Encashment letter needs to be provided by Meghalaya Council and NOC, yes. So. Who can clarify with regard to this lien? Any banker out here, bank?
Bank has already clarified lordship
Yes.
in its email only. So we will not write it.
Lien marked in the name of Hindustan Steel. Lien is marked in your name.
But we cannot encash it, your lordship. The essence of the EMD is not followed, your lordship.
An encashment right of FDR without any concern and supply. Where is the fixed deposit they have submitted? FDR, where is the FDR?
Page number 135.
135. The Hindustan Company Limited, they have a deposit payable to as fixed deposit treasury unlimited, payable to. Where is this? Can you give me a copy? Where is this? Where does the bank say that there can be FDRs issued which can be encashed by the by the person in whose name it is made?
Lordship, the bank's email reply file reads, Lordship, FDR number so has been issued on 14/1/2015 and the maturity date will be so. And the same has been marked lien with remark NOC required from HSCL.
Mark lien means what? What does mark lien mean?
Lien means, lordship, neither I can fully encash the bank FDR nor he can. Consent of
From where
both
do
the
you say that? From where do you say that? What is the basis for you saying that? Have you read it in some comic book or in some medical book or from which book? Banking book or something? From where? Your basis has to be something. You have said that lien means so and so, so and so. I accept your submission. But from which book did you take it out? From a story book, fairy book, class one book? From which book? Banker's book? What?
If it is not any book.
Then from where did how to accept?
But essence of.
Because it does no. I understand your case perfectly. Only problem is to write an order. I have got to write it so that people understand. Now I cannot say that the law officer of that company said this, so it has to be the truth. It is the banker's word. So the bankers, when they use the word lien, it has to be based from some circular, some book, something that has to be there. So you show me when the bank says lien, what does it mean? Not, I do not want your explanation. I want the banker's explanation.
You have to arrange it with the other
Naturally, supposing you use this is regarding some chemical supply has to be made with regard to health department, and it says it is a pathogen or is a pathogenic disease or something like that. Now, what is that? What do you mean by pathogen? I cannot accept what you say as a businessman. I have to accept the meaning of pathogen or pathogenic diseases as per what the medical dictionary says, not as what you say. You have got to, you see, I can say anything. Supposing I say regarding the Mizo language, my language, I can give a definition of a word. I can say this means this. You say that then your understanding, where is the book or you rely upon? The supporting document on the basis of which we can say that yes, what you say is correct. That has to be there.
Yes, when this matter will be, on a merit basis, but before, then this matter is listed for the jurisdiction, territorial jurisdiction.
Mr. Counsel, your case is not around territorial jurisdiction. Your case is with regard to the the power not being with you to encash the EMD. That is the issue. Okay, so you please explain this EMD. What does the lien mean out here? What does the word lien that is being used by the bank mean? So that is what then what am I doing? Okay, you have challenged it. So they were raising some other thing. There is a territorial disease. Yes, now let you make the submission. Let me hear you. You are raising an issue, I'll hear you.
Lordship, in our affidavit in opposition, we have brought the integrity.
Mr. Counsel, you please get a lawyer to represent you or you argue without a lawyer. You cannot have it both ways. Yes.
Your Lordship, in our affidavit in opposition, we have brought on record the integrity pact, Your Lordship. Lordship, there was suppression of material facts. This integrity
You
pact.
see, Mr. Counsel, are you going to talk about the merits of the case or are you talking about territorial jurisdiction?
Territorial jurisdiction.
So is the integrity pact
Yes, Your
an
Lordship.
issue of
Yes, Your Lordship,
it encompasses that issue?
Yes, Your Lordship, the jurisdiction is
Page
401 of the
Huh?
401 of the
401.
section 9, Your Lordship.
401. Yes,
Section 9.
section 9. Yes.
1, Your Lordship. This agreement is subject to Indian law. Place of performance and jurisdiction is the registered office of the principal, that is Kolkata, Your Lordship.
So?
They have specifically agreed that any.
No. This is something else. Is there some arbitration clause out here?
Yep, 6, Your Lordship.
6.
It is agreed term and condition that any dispute or difference arising between the parties with regard to the terms of this integrity pact, any actions taken by the principal in accordance with the integrity pact shall not be subject to arbitration.
Shall not be subject. That's not an arbitration clause. What is the agreement? It's for construction?
Yes, sir.
Construction of a training check.
Construction where?
In Assam, your lordship.
In Assam.
But the work has not started, your lordship.
Whatever. The construction work is to be done in Assam. Huh?
Your lordship?
Construction work is to be done in Assam.
Yes, your lordship.
If it is to be done in Assam, then why should it be Calcutta?
Because they've agreed, your lordship, as per the integrity pact,
They have
and
raised
work
the
has
topic
not started, your lordship.
Let's see. Wait. The petitioner's counsel is granted a week's time to file reply affidavit. Leave the matter after the.
Right, thanks.
I mean, I think we. Yes, what is your case?
This case with regard to the settlement of the IMFL retail off license.
Huh?
The settlement of IMFL retail off license shop. Document.
Yes, what happened?
Well, the tender was
Tender dated NIT
23 to 2024. That is rebid. Initially, there's another
Okay, this is a rebid. So the earlier bid, that's finished. That's not required to be gone into. Correct.
The terms and conditions will be
Whatever.
earlier.
Okay.
Yes, partner.
Okay. So where is that terms and condition? Which page?
Well, we took for this page 21.
21. Yes.
But this we are confined to two of the clauses, that is 2.1 at page 29.
Page 29. Yes.
An individual, a partnership firm, a limited liability partnership LLP, or a company interested under Companies Act 1956 or subsequent enactment who has proof of filing income tax return for 3 financial year out of the last 4 financial year, 2019, 20, 20, 21, 21, 22, and 22, 23, duly certified by a certain accountant who is eligible to participate in the bid. Now,
So ITR for 3 years. That's
3
all.
years, that is to be certified by the chartered accountant. So the respondent, did not have the certification from the chartered accountant. And he has been declared L1. And this issue has already been decided by.
R5, yeah, R5, respond number
Uh,
5.
This issue has been decided, your lordship. That is certified by chartered accountant. This is necessary, your lordship.
Is
Necessary.
necessary.
Yes, he has certified, but that order is challenged in the division bench, your lordship. It's a pending
stay order.
stay order. Let the division bench matter be.
What?
There is
Different district, this is a different district.
But-
and every district has.
In some
some
it was-
district, they say CS required,
Necessary,
some
some-
CS not required.
That we did that with Tinsukia district only. I don't think they have any other, ID. So far as this is concerned,
But the honorable said that this chartered
I
account,
think they have, okay, so that has not been decided.
they are only decided. May I please? I'll do that for your election.
Para 30. No, out here in this judgment, what has been said? That it should be as per the tender conditions.
Yes, sir.
It should be certified by DC.
So it's in your favor, this judgment.
But that has got the division bench. This
Huh?
order has been challenged in division bench also.
Maybe, but then I'm still bound by this.
Judgment has not been stayed by the division bench.
Sorry,
By
I'm
this
still bound by
judgment-
this.
By this judgment, my lord,
You see, because out it's been clearly stated that it should be certified by a chartered accountant. Unless it is your case that this is not an essential condition of contract. Is it?
And
No, no,
another issue is that the signing of the bid documents are also. The petitioners have not signed every document of the bid also.
That's a different issue.
That's
That
different.
it can be reconsidered, but then the respondent number 5 cannot be considered.
So this order, Lordship, the new fresh tender was floated. Thereafter, the division bench ordered subject to outcome of this appeal, Lordship. After this order, they challenged the division bench. Thereafter, fresh tender was floated at that district. Thereafter, the division bench ordered subject to outcome of
The
the
tender there would be subject to the outcome
outcome
of the.
of the
district.
relative. The law.
That will be here also. The respondent number 5 can go and challenge it. Yes, madam. Who is the senior? Huh? M. Biswa. Nothing survived. Why should we? So we're disposing it off. Tell your counsel to come. Tell him to come. I'm disposing it off now. He doesn't want to come.
One aspect, here the technical bid evaluation has rejected on my tender non-responsive.
Acha.
Yes, yes.
Sorry. Your tent has been rejected.
Yes, non-responsive. That is good.
Then what right do you have to challenge this respondent number 5 tender?
I'm selecting the technical bid evaluation that report.
You challenging that, okay.
Now, so for
So let us go step by step. You have gone to the 3rd floor. You have got to first build your first and second floor. Let us see let us see your disqualification.
73.
Page 73. Page 73. I thought your case was only the issue with regard to that chartered accountancy. It's not. Yes, page 73, yes.
So far as his selection cannot be sustained, but that was this give you, and so far as whether my rejection.
No. You see, sorry. Unless you overcome your deficiency first, you cannot make a challenge to others.
But this round of the one which has already been disposed of, the similar issues are also there. The petitioners, tender assurance, rejected on different grounds.
Correct.
But then,
So they have got to succeed.
but then
They succeeded here. Correct.
ultimately retender has been directed to the issue.
Whatever it be done. No, you see, as per the judgment in Ronak's case and Tata Motors, a person whose technical bid has been rejected, he cannot be allowed to challenge the selection of another person when you yourself are disqualified. So you have got to first show this court that your technical bid is also
Yes, that is.
your technical bid is also.
The grounds on which my tender has been found to be non-responsive are non-existent.
Let me see.
This page 73 is the technical evaluation, which it may come to page 74. 5. 76.
Yes.
The extreme right hand side, serial number 3.
Yes.
Rishabh Kumar Bharat. Affidavit regarding no excise shop license for the previously submitted.
Yes,
This has been submitted, but I have enclosed.
you have submitted.
But
Okay, then,
then signature of bidder not found with some uploaded documents which is mandatory as per guidelines. So this second requirement, the respondent number 5 also did not sign many documents.
okay, so,
Documents also I have signed. So therefore, they cannot take a double standard where they have relaxed the condition with regard to the respondent number 5. Same benefit method should be given to. So this is the ground. So these both the grounds are non-existent method machines.
is it your case that the affidavit that you used in the subsequent rebate was the one that you used in the earlier petition?
But there's no bar, madam, because affidavit is required. Because after the madam,
So please clarify everything. Don't leave things hanging. He'll argue that, he'll say that, no, it was used in the earlier one, then you'll clarify. You could have clarified it, the second sentence. And this, and with regard to the signature not found in some uploaded documents. What?
We have to consider there is no signature in this. There are documents submitted by him, there is no signature. That's like.
But he said that there is no signature by the respondent number
Well,
5.
we have the documents that is respondent number 5 also.
It's all there.
It's all there. There's only one signature is not there, and the document is not necessary for a tender. The lordship.
And where is the tender conditions page regarding this signing signature?
clause madam, 6.
Clause 6,
Clause 6.
page,
Page 34.
page 34. Yes. Page 34.
But regarding 6.2.5, that is requirement which.
6.2.5.
It is regarding that income tax certificate to be certified, that is not.
That is income ITR. Okay, then
Then madam, so far as affidavit is also been find 6.2.8.
6.2.8.
Affidavit in annexure B. on
Affidavit.
Under rule.
Okay, then,
So that we have given.
then signature.
Page 40, your lordship, 10.4. 10.4.3, the AP document shall be digitally signed at time of uploading my document. The hard copy shall be signed
Page 40, 10.4.3.
3 and 10.4.4.
This is like this clause 7. Come madam, page 20.
Page
Page 40, your lordship.
37. What about 37?
37 for the serial number 7, procedure to apply. Serial number 7.6. All pages of documents submitted by the bidders shall be signed by the authorized signatory and shall also be.
Where are you reading?
Page 37, clause 7.6.
Yes, I don't have 7.6. There is no 7.6.
There is 7.6, it's not legible actually.
Basically, perhaps, madam, because I am,
It's legible in that copy, your lordship.
Not very, mine from 7.4, it jumps to 7.7.1.
Yes. Fine.
Seven point six is also reflected page 40, 10.4.4.
Just take this. Clause 7.7. Of the, what is this? Of the what?
7.6 of the bid document.
Of the bid document. And 7.7. Not 7.6 and 7.7, huh? For the bid document states as follows. Let's take it down. In my copy, it's not there.
It will be 7.6.
7.6 and 7.7, both. So, your name is? Petitioner name?
Reserve. I have submitted his documents
So,
by way of an additional affidavit. Whether I can get the list with the.
so this respondent number 5 has signed all documents.
But these are the documents that I have submitted. Downloaded from the website.
I have got the original. Except for one page, you said.
Except for one page.
Which page?
I hold on.
You didn't mark it.
After the publication.
And this is the petitioner.
Whether these signatures will be obtained later or what, because these are all downloaded from the portal.
Look, Mr.
Yes.
Counsel, their case is that you did not sign all documents. There is no question of obtaining your signatures when their case is that you did not sign all documents. They will not obtain your signatures in the future. They might want to do the vanishing trick. That's a different thing. Not,
The respondent.
I don't know. That too is the question of fact.
So here, these are the documents because from there.
I'm sorry, Mr. Counsel, this is a writ court. We cannot go into those issues.
But this one,
There's a document.
some determination, some inquiry, how this, the documents which have been.
Sorry. You can go, that too I will not accept.
And even if one is not, one page is not submitted, in that case, that clause 7.6 should be mandatory. Because it says all pages.
The document which the bride is have not signed. It's a tenancy agreement, the lordship, and in the document, in the clause 6, it doesn't say where you have to annex that. It's just a extra document which they have given to
It's
the
an extra
authority. This is the extra document.
But one thing, Mr. Gogoi, it's just that all pages of the document submitted by the bidder shall be signed.
Salvation.
Yeah, all, but whether it is a required document or not, doesn't have
But
a prefix.
clause 6, a lordship, clause 6 of a tender document, which is a document compromising the bid.
Clause 6,
6
clause 6.
of the writ petition, page 25. Here,
Compromising the bid.
yes, documents which are needed to be attached to the bid document, the lordship. The respondent number 5, it's given a document which is not even required in the clause 6.
And who is this other person? Tarun Kumar Bara? Who is he? Where is the petitioner's
I give it
document? This is the one.
This
This is Rishabh Kumar Bora.
Rishabh Kumar Bora.
Okay, income tax return. He has not signed this. He has not signed this. Okay, many documents. Oh, okay, but there's only one aspect. Okay, there is no problem with the disqualification of the petitioner. But what about the judgment of the coordinate bench,
Yes, Your Lordship.
wherein it has held that the
CA certified.
CA certified ITR has to be submitted? And his is not a CA certified.
That's one thing. Even taking into account that the CA certified is necessary, even one reason is enough to disqualify a bidder, Your Lordship. One
Correct.
reason is enough.
Correct.
First, even though we accept that, all right, that his documents CA certified is not there of the prior respondent, it's wrong. But what about him? He has been disqualified just first reason because of this non-signing of document. You have to show that I have given,
No, but then you see, the issue is this. When this court has already taken a decision
Yes.
on a certain issue, I cannot close my eyes and pretend that it's not there. It is there. When the court in other cases has held that the bid of a person which does not have a CA certified ITR has to be set aside, then nothing
That
remains.
order has been consideration before division bench. Your Lordship.
So let-
Section we have to-
But then maybe,
And the tender was left. So they got to, yeah,
huh?
The division bench will state the tender for the banking.
Huh?
No, not state. It has been said outcome of the result of the legal. The subsequent tender process which was floated after the judgment. The outcome,
Because he is not eligible, neither are you.
that even it is for the government to take a call.
The both are at fault, Your Lordship.
That is why the government, since it's here, why should I take a call? I can't do it.
But here the petitioner will have to stand on his own leg.
Correct, that is there, correct, but then he has shown me this order passed by a coordinate bench, which requires the bidder to have submitted a CA certified ITR. And you have not submitted CA certified ITR and still got the contract.
Since it has been decided by a single judge, my lord, so probably before another coordinate bench, I cannot perhaps make any otherwise argument. But my lord, I have my argument, I have even annexed. It is the ethical committee of the Chartered Accountant of India have clearly said that a chartered accountant is not supposed to sign the ITR return. What he is supposed to sign is the balance sheet. He cannot sign because these are computerized generated thing. Now suppose I am an advocate, my lord. Can I authenticate an affidavit? No.
Look, Mr. Counsel, I'm not on that.
Yes, absolutely. I understand my.
You see, the issue is only the author of the tender
Absolutely.
wants a thing to be done in a certain way. And there cannot be a
Absolutely.
judicial review of
Absolutely.
that. And it's not that condition has not been challenged by you also. You have accepted it.
My lord.
You have accepted it. Unfortunately, you have not complied with it.
My bid may be subject to the outcome of the legal my lord. That at best that can be my, as far as my bid is concerned, my lord, but his bid is bound to fail, my lord.
His bid is bound to fail, no doubt.
My
Okay, but
bid
you
may be at best, my lord, it may be subject to the outcome of the legal my lord.
It is not liable to be failed because but 7.6 says all pages of documents submitted by the bidder.
no, but it will have to be in conformity with clause 6.
But there it's a bid should comprise the documents. Then but here all pages of the documents. It does not say.
It has to be read in conjunction with clause 6. It cannot be, no. You can go in a field in that.
But this, clause 6.
No, no, you see, I don't think so. Someone can put in whatever he wants, maybe his date of birth also, his uncle's date of death, his auntie's date of birth. That is not part of the bid document. So that cannot be a ground for rejection. It has no nexus to be to the object sought to be achieved by the tender. That is something different. We'll have to differentiate also. I mean, when the terms and conditions are there, it is for what? It is for the object to be achieved by the tender. When he has submitted documents which have nothing to do with the object sought to be achieved and which is not required, then how can we use that as a basis for disqualifying him?
But then, consider seen, at least one page is not signed.
That is the one that not required.
That is, apart from that, what he is pointing out, that is one document. So far as what he is saying, the tenancy document is not a part of the bid document, so it is not signed. But the affidavit submitted, my lord, that is also not signed.
Which affidavit?
The annexure B,
Huh? No,
that is as per clause 6.2.8.
his document.
Is
Respondent number 5 document.
6.2.8, that annexure B.
I don't know, I think it's signed. Sure.
That is original affidavit.
Everything is signed there. How it has been signed, I don't know, but it is signed.
So signed, that the document is signed, but not for the purpose of submitting in the tender, it has been signed.
When it's written, then original document, we have to put another signature and all together.
When an affidavit is to be sworn, a person has to swear the affidavit, then only it become a document. Now, when it is submitted with the tender.
Which affidavit? It has been signed. Yeah, what do you mean that has not been signed? It has been signed. Which page is it?
It should be there.
I don't know. I cannot go look for 6.2 or something out there. Let's wait. Which one is he talking about? Let me see. David, that's the only thing I'll hear. That's the end of the matter after that.
These are the original affidavit.
I know. No, which one does he?
6.2.
No. This is online tender, no?
Online and offline. Both.
Online has to be signed.
Online has to be first.
Yes.
So online has to be signed.
That is 10.4.3.
Show me the online. Whether it is signed or not. Original documents will come later. There's no requirement of signing in original. You're not going to submit your original.
If I understand correctly, an online document will be scanned and will be uploaded to the system. Now, once there is an original, I'll scan.
That should come to page 40. Both edit as well as the hard copy, both need to be signed.
You see, it says here. The registered bidder shall also be required to sign, scan and upload all pages of his bid document. Prior to that, it says, all pages of the document submitted by the bidder shall be signed.
Absolutely, my lord. There is no dispute on that. My lord, what I am submitting, my lord, is that suppose I have, say for example, I have one ITR return with me.
Yes.
Now, this ITR return, I'll sign, I'll put it in my scanner, I'll scan and I'll upload it in the system. Now I have an original affidavit. Now it is signed by me. They already bears
Already signed, correct. That is
I
not
will
required.
scan. That is what he's arguing, that scan copy is not signed. How is that? Because I am scanning from the original copy where my signature is there. I am not scanning a.
Anyway, let us see.
These are the affidavits, it's original, my lord.
I do not know what is. Anyway, let me see.
So can you look into cross 10.
Back is to the wall, so.
Let's take a look to this clause 10.4.3. The ED documents shall be digitally signed at the time of uploading by the authorized signatory of the bidder. The hard copy shall be signed by the bidder or his authorized signatory with the entity sealed. So both need to sign.
Yes, it is signed, my lord.
Before. Annexure provision, the petition talking what is assigned.
Then also remain one document is not signed. madam. If it is
Maybe,
there-
but that is not a requirement.
No, no, they are not saying about the tenancy document. They are saying that the documents comprising the bid. in
No,
one
that
copy-
has all been signed.
No, there one copy that has not been signed. That was the submission. The document comprising the bid, those bunch of
No,
documents.
no, there was one document that was with regard to
That's by this.
this,
Middle cycle.
Ah.
And that's not even required in the bid document. at all.
not required. This is not required. Are you sure?
Yeah, this middle cycle because,
It's not, this is,
because it's between, clause 6 a lot.
this is Sitananda Saikya, Hazarika.
The Sitanda hospital, that's required, the signature is there. But there is one document only signed by one middle cycle lot. There's another notary document a lot.
But you can pick up this, but after some time.
No, not,
Original,
no,
I
no.
just look.
No,
for
no,
original.
no.
Well, at least,
No.
I'll.
I've taken enough time. No. Sorry.
Only for time being, but I'll go through.
No,
the,
no.
original
No.
document, What about the government report?
You should ask this or not after I've decided what to do with it.
But the government did not, dispute whatever I have contended. They have not contended. Another
This document, which is not required. by one middle.
Who is this Mridul Saikya?
Is most probably the owner a lot of us.
That I'm the absolute owner of plot number so and
Yes,
so.
that document is not required. It's not even necessary in the big document, clause as per clause 6. As per clause 6, this is not necessary. They have just annexed it.
My lord, what is necessary is that agreement which you have given. Now, this is an affidavit by the landowner as an abandoned precaution my client might have given. It is an affidavit by the owner of the, that is not a part of the bid document as well.
It is part of the bid document, but it is not
Not a
required.
part of the document that is required to be submitted along with it. Sometimes abandoned precautions also boomerang. It's a classic example.
What to do? Will it boomerang? Will it boomerang?
At least it has been some scope of argument, otherwise, notwithstanding that, my lord, this is not a part of the, not a document that is supposed to be.
But whether you can be given the license.
But that is the take the government will, my lord, it is up to the government to decide, my lord, is something or not.
Okay, right. Right, Mr. PJ Saikya. Learned Senior Counsel. Assisted by Mr. Learned Counsel for the petition assisted by Mr. AJ Saikya. KJ Saikya. Also heard Mr. R. Gogoi, Learned Standing Counsel for the Excise Department. And Mr. M. Biswas appearing for the respondent number 5. The petitioner's grievance is that his technical bid. I've given some long order earlier, no? You take this order dated 21/3/24. Earlier, I have made a, okay, then para 2, para 3, para 4, para 5. Para para 6. No, para 5, no, para 5, then para 6 only. The petitioner's counsel submits that a coordinate bench of this court in
Let's just interrupt you one. Just for a moment, madam, the clause 6.2.12. Copy of the document showing the bidder's right title and interest on the proposed site or the land where the tenancy agreement comes. This is a document comprising the bid document. At page 36. Yes. Clause 6.2.12.
Yes.
Copy of the document showing the bidder's right title and interest on the proposed site or the land. Okay. This document is there, my lord, under clause 6, document comprising the bid. So he has submitted the tenancy agreement, showing his right.
No, this is not a tenancy agreement.
It's a document signed by one business.
The one business idea
It's the owner of his.
Tenancy agreement submitted.
Agreement. So tenancy agreement, my lord, I have.
Tenancy agreement different.
But tenancy agreement, I have, but and by way of additional affidavit, I have submitted.
Yes, show me where is page.
At page 101.
No, this is different.
Tenancy agreement.
Correct, that is tenancy agreement, but the one he has not signed is a different thing. It's nothing to do with this respondent number 5. His signature.
Whether these tenancy agreements are signed, my specific instructions is not signed. Tenancy agreement.
Yeah, sure, whether this is signed.
Yes.
Tenancy agreement.
This tenancy.
Whether this page 102 is signed, I don't know, there's so many documents.
If I may, Lord Chair, I'll put.
Yes, let me see.
His submission is that tenancy agreement is not a part of the bid document.
No,
That's-
sorry.
That's a declaration by the landowner.
Yeah. That's a declaration, that's the under one.
There is an unsigned agreement, my lord, or agreement for signed agreement.
Maybe so, yes, even the other issue. So many documents, probably. Yes, show me where is this, I don't know. Whole bunch of them. Where am I? At disposal or had in a similar case. Yes. Page 101.
Okay,
This is the document.
Sitananda
Other agreement.
Azarika. In 102 also it is there.
Yes, it's continuation placement.
102 also, 101 also it is there, even in your copy it is there. Even in your copy it is there, and the sideways.
This is the tenancy agreement executed.
Correct.
Now, while submitting in the tender, that has to be digitally signed by the bidder, and also the hard copy to be signed again, re-signed.
It is signed, it is signed.
Unless
It is signed, it is signed.
unless these two signature
It
agree
is signed.
signed.
It is signed.
But apart from this,
No, enough. No more. I've had enough. Right, what do I say? In this earlier case, he set aside the tender. Set aside the allotment of the tender.
tender was
Listen, set aside the tender allotted to the bidder who had submitted income tax returns without, which had not been certified by the chartered accountant as mandated in clause
one.
as mandated in clause
Page 29.
2.1 of the bid document. That is in WPC 1384/2024 and others. He submits that as the respondent number 5 had not submitted an income tax return which had been duly certified by a chartered accountant in terms of clause 2.1 of the bid. The award of the tender to the respondent number 5 should be set. And a fresh tender should be published, should be issued. Next. Mr. D. Gogoi, the R.R. Gogoi, the learned counsel for this excise department, submits that the petitioner did not sign all the pages of his uploaded tender document. And as the same was a mandatory requirement, there was no infirmity with the disqualification of the petitioner technically. Okay, what about that he had used the earlier affidavit in the subsequent, in the present affidavit? Regarding having no shop or license.
That being said, he has submitted earlier, Lordship.
Correct. So which he used earlier, he's using it now. What is wrong with that? Are you challenging, are you saying that this is wrong?
If he obtains the deficiency in the intermediary period, suppose my lord, I submitted affidavit in the month of May, and the next tender is in the month of September, say for example, from May to September, if I incurred the inability during this period, so that is why a reset one is required.
No, that is your interpretation. Sorry. Very good try. I didn't ask you also anyway.
But the authorities are not saying anything regarding that affidavit, Lordship.
Mr. D. Gogoi, on the last date, a few months back, I remember, had admitted that it was okay. Then I want to record your statement now, because that has been recorded in the order dated 21/3/24.
You have submitted earlier, the affidavit has submitted earlier.
Correct. Fairly submits that there is no bar on the petitioner to submit the affidavit submitted in response to the earlier NIB dated 6/1/2024. In the present, in the present NIB dated 23/2/2024. Next para. Mr. the RR Gogoi submits that all the documents in the bid submitted by a tenderer need not be signed. He submits that the documents that comprises the bid is clearly provided in clause 6 of the NIB and clause 6.2.1 to 6.2.20 specifically provides the documents that have to be submitted by a tenderer. It is only those documents mentioned in clause 6.2.1 to 6.2.20 that have to be signed. And documents which do not pertain to clause 6.2.1 to 6.2.20 need not be signed, as they are not required for considering the bid of a tender. Yes, sir. He submits that. No, next paragraph. Mr. Aragoy submits that the respondent number 1 had not signed one document. The respondent number 5
document.
had not signed one document. That is that is a letter. What is that? What is that again? I've got.
Declaration of the land.
You should have put it sideways or something. Again, I've got to look for it. That is a declaration made by the owner of a plot of land. Owner of the plot of land stating that the land is his land and that it is free from any encumbrance. He submits that the said document is not a document required under clause 6.2.1 to 6.2.20. Inasmuch as the respondent number 5 and the landowner had already submitted a tenancy agreement wherein a tenancy agreement in terms of clause 6.2.1 to 6.2.20, which was signed. Next paragraph. Mr. R.R. Gogoi has submitted the documents submitted by the petitioner and the respondent number 5 for perusal of this court. On perusal of the documents submitted by the petitioner, it is found that a number of documents, including the ITR of the petitioner, had not been signed by the petitioner.
Original of this all are submitted.
No, that's all right. But the photocopy is this is they have not got it. I don't know from where they've got it.
Yes, without photos, they scan copy.
These things, Mr. Council, what to do? We are read court.
Is there, but they, which documents I don't have signature, it is, they have not mentioned, Malata.
Oh, you want me to mention? I can mention. There's 1, 2, there are lots. Okay, right. There are more than. No, a glance at the documents submitted by the petitioner shows that there are more than 10 documents that have not been signed by the petition. Which includes not only the ITR, as mentioned earlier, but also police verification report. Etc. Anyway, right. Don't say just say that anyway, that I'll correct it. Why should I go into that aspect? When ITR is not signed, that's enough, I think. Okay, next. The document submitted by the respondent number 5, on the other hand, shows that the petitioner had not, the respondent number 5 had not signed one document. That is the affidavit made by the owner of the land, which is not a required document in terms of clause 6.2.1 to 6.2.20 of the tender notice. Next paragraph. In view of the fact that, next paragraph, in view of the fact that the petitioner's technical bid had been disqualified, not any, bid had been technical bid or bid? Bid, no, one bid. The bid had been disqualified.
Technical bid.
Technical bid had been disqualified on two grounds. And even though the respondents have accepted the fact that the rejection of the petitioner's bid on the ground of having submitted an affidavit with regard to having no excise shop / license could not be sustainable, the absence of the signature of the petitioner on the bid documents pertaining to clause 2.1.1 and to clause 6.2.20, 6.2.1, 6.2.1 to 6.2.20. Cannot be a sale. Cannot be a sale. As the same was not, the same was in violation of the tender notice. Accordingly, this court is of the view that the petitioner not having given his signature to all the bid documents pertaining to clause 6.2.1 to clause 6.2.20. In as much as amongst the documents submitted by the petitioner, even the ITR documents have not been signed by him. There is no infirmity with the disqualification of the petitioner's tender on the said score, on the said count. Next para. In respect of with respect to the question as to whether the respondent number 5 could have been awarded the tender despite not having submitted chartered accountant certified income tax returns, this court finds that the terms of that the requirement of submitting ITR returns duly certified by a chartered accountant is an essential condition of the tender in terms of clause 2.1 of the NIT. So both of you, in that way of the matter, this court finds that the award of the tender to the respondent number 5 could not have been done by violating an essential condition of the tender. Consequently, the allotment of the tender, awarding of the tender in favor of the respondent number 5 is not sustainable in law. The same is set aside. Acha, one thing you're right, huh? Before that, you're right, I forgot about his submission. I did not record any submission of it. Mr. M. Biswas, the learned counsel for the respondent number 5, submits that the issue as to whether the ITR is to be duly certified by a chartered accountant as required under clause 2.1 of the NIT is under consideration before the division bench of this court, in as much as a challenge has been made to the decision of the judgment of the single bench of the coordinate bench of this court in WPC 1384/2024 and others, wherein it was held that wherein the allotment of tenders had been cancelled, when the allotment of tenders to bidders who had submitted ITR which were not certified by chartered accountants had been cancelled. Any other thing, so you don't have anything to say?
Because my submission is not required. Anyway, since it's learned.
That's right.
I think it's submitted.
He submits that those clause 2.1 of the NIT, of the bid document requires chartered accountant certified ITRs to be submitted. The same is not a requirement in terms of
But the same is not a requirement in terms of. The resolution by the Indian Council of Chartered Accountants. In terms of the decision of the Institute of Chartered Accountants of India, which is published in, this is page 110, the published in, this is the name of the book, FAQ on Unique Documentation Identification Number, UDIN.
you say once more, slowly, once more you say.
Published in FAQ, all in capital, S small, on Unique Document Identification Number within bracket UDIN.
Okay.
He's only supposed to sign the profit and loss account and the balance sheet.
Okay, come back. Where are we? Full stop. This is, full stop. And before that, this is due to the fact that judicial review of the terms and conditions of a tender is not permissible as it is in the realm of contract. The same could only be done if it was arbitrary, discriminatory, malified, and there was a likelihood of bias. In the present case, there is no challenge to clause 2.1 of the NIT by any of the parties. Full stop. Next para. In the case of, you will put in Ronak, put in Ronak International, then put in Tata Cellular, and then Datta Associates. Okay. Consequently, the impugned consideration is hereby set aside. The respondents are directed to issue a fresh NIT. For allotment of the IMFL off license. Huh? That-
It's better that to be fresh environment. Let them come up with correct document.
No, they have to, this is going to cause trouble everywhere. His case, he doesn't, his case, was not that good. But then because of the judgment, your case has gone. And it is correct also, the judgment.
Yes.
Anyway, so in the end, he succeeded.
At his own peril.
Both failed, but both succeeded.
He succeeded at his own peril.
Yes. Sometimes operation successful,
Operation
patient dies.
dies.
But here, operation failed,
Patient.
patient survived. I don't know.
How like that?
So this item, AC, very hot.
Affidavit we have filed. We have filed.
Item
There is
6.
some urgency, my lord. Medical equipment have to be supplied.
You have to file reply earlier,
Yeah, file or reply, but however, the same is not on the report.
huh? Not on record.
Today the private exporter has appeared for the first time.
Waiting for document for detail.
This matter pertains to what? Supply,
Supply of medical equipment.
and you are the successful.
They can come up detail.
Tuesday?
Yes.
No, we've got a lot of matters there.
Sorry, 15. It will be on Friday. So Friday will be difficult for admission in India. Otherwise, we are, if it is possible on Friday. Not inconvenient. On 6th ground, well, the petitioner will be there. 6th ground.
See, he's trying his luck.
Yes.
You've got a good case. Huh? You've got a good case. So he says he's got a good case. If he says he's got a good case, then I'm going to have a hard time. Okay, when do you want? You'll agree.
Either 16th or 20th. 20th is a Tuesday.
20th, on the prayer of the parties, list the matter on 20th.
Yes, sir.
Interim order to continue till 20th.
My sincere apologies, madam. So I informed the department, but they are releasing more. Okay, and part of an amount was released, but the other.
No, tell me one thing. What is the instructions you have received? Are you,
Instructions I have received is a lot, since there is a change in the MD, they are unable to trace out the vouchers, the earlier vouchers, and the general manager who was dealing, he had some operations, my lord, and he is yet to resume the office. For that,
when is resuming office?
he has some kidney operation, my lord, in Apollo Delhi,
When?
last week, my lord.
Lordship, on the last date, your lordship had observed that, in case they did not release the amount by today, strict direction or order will be considered.
I have not recorded that. How much is the remaining amount payable to you? Six crores.
Yes, my lord, 3 crore, 2,74,290. And the actual amount that we have paid is around 84,13,787.
And reason do not appear to be qualified.
So that is the instruction that I have received.
We will ask them to appear or what?
Yes, my lord,
Huh?
so I will to see which possible.
What is this,
And there, the MD has changed, my lord. On the, even the some Dr. Sadiq C.
that heard Miss M. Das appearing on behalf of Mr. P. Manta, learned counsel for the petition. Also heard Mr.
A. Deka, my lord.
A. Deka, learned counsel for
Respondent 3.
the point number 3. This court, while order dated 30/11/22, passed in WPC 1594 of 22, had directed the respondents to pay to the petitioner rupees 3,86,88,077 for the supply of livestock and poultry feeds with interest at the prevailing bank rates. As the same had not been done, the present contempt petition was filed on 7/12/2023. During the proceedings of this case, an amount of rupees
84 lakh 13,787.
84,
13,787.
13, 787 has been paid to the petitioner. Next paragraph. During the proceedings of this case, various orders have been issued wherein it has been recorded that the government of Assam finance EC-1 department have given concurrence for financial sanction to clear the liabilities of the petition. Next part. The order dated 1/4/2025 passed by this court has recorded the submission of the counsel for the respondent number 3, which is to the effect that the funds for payment of the dues of the petitioner has been received. Full stop. However, as there was a change in the post of managing director, 10 days time was taken to receive further instructions. Full stop. Next time, when the orders passed by this court show that the government of Assam Finance Department has approved the sanction of payment to the petitioner and money has been received by the respondent. Number three, there can be no justification for withholding the payment in violation of the order of this court, which had been passed more than 2.5 years earlier. This one. Who is the managing director? Anil Chandra Jury.
At present, one Sadnik Singh. He will need to be.
Read him. I want to call him and you read him. The respondent number 3 is directed to. No, the Mr. Edeka will obtain instruction. No, as to why the amount has not been paid till date. Why the respondent number 3? What is his name? He also submits that the present managing director, Assam Livestock and Poultry Corporation, bracket ALPCO, is
Dr. Sadnik, S.A.
daughter
Sadnik,
SADNEK
N.E.K. Singh.
Singh. So, on considering the above, on considering the oral next para, on considering the oral prayer made by the petitioner's counsel, Dr. Satnik Singh, ACS, or what? You don't know. Managing Director, Assam Livestock Poultry Corporation, bracket ALPCO, Khanapara, Guwahati, 78100022, is impleaded as respondent number 5. The petitioner shall submit the corrected cost title to the registry within 3 days. Next para, issue notice to the newly impleaded respondent number 5. Issue notice to the respondent number 5. Petitioner takes steps for service of notice upon the newly implemented respondent number 5 by registered post within 2 days. In 2 days. I think the early one also make it 2 days, that cost. Notice returnability 3 weeks, huh, you say. This is the matter. After 3 weeks to enable the respondent number 5 to make submissions as to why the petitioner has not been paid his dues. Tell them to take it seriously. When do we fix your date of the TV? Hold on, is not free. Huh? There is what date? Make it 30th. 30th May. No problem. Yes.
Should may please come to order dated 9/4/2025. 9/4. Procedure. It is the page 3 of the order at the
Accordingly, this court permit the respondent counsel to produce the relevant record before the court of his accepting. As to whether the financial bids were open or seen by the respondent authority in the process of the third tender for calling for the fourth tender. In my in the record, that's all right, Lordship. Otherwise,
Yes, I am ready with the records.
and the start effects. Yes, I'll start, Lordship,
Just a minute.
for that.
Yes.
So this document, Lordship, is now here. It is shown that the financial bid is open, Lordship, down below 1 and 2, Lordship. My client is Ranjit Burwa, the petitioner. Financial bid, it is open. And the date and it is from the online, Lordship. Their own, Lordship, I have taken. So, if Lordship, I prepared an affidavit, if Lordship said, I'll complete my argument, I'll file the affidavit because my client is there in Withdrawal. So, it will come tonight. So I have to file the affidavit.
February 2024, my lord, the tender was cancelled. Now, my lord, we are lingering for almost a year, my lord.
No,
Petition
Lordship,
has been from
my-
2019,
all
my
right,
lord. Same
Lordship,
petition.
I'll complete.
Every day, my lord, some one reason for the other, my lord, this matter.
There is a court order, Lordship. It's not my order, Lordship.
No, no,
Court
that I
said
have.
that
I have
whether it is open or not. It is
No,
open.
What affidavit do you want to support?
Only this document. The Lordship will see, Lordship, no problem, Lordship.
This is open.
Yes, Lord. Lordship, may please come to the petition. Lordship, may please come to page 33 of my writ petition. Writ petition, page 33. This is 3/10/23, Lordship. This is the e-tender through the e-tenders are invited through e-procurement system, that is through www.assamtendergovernment.in. Lordship will take note of this one. This is the first tender at page 33. That is dated 3/10/2023. My client participated, Lordship. Then, Lordship, again a retender. That is the next page, page 34. Yes. It is named as retender, Lordship. Retender are invited. It is retender now. It is on 6/11/23. This is next.
16 or 6/11?
6/11.
6/11.
It is 16/11. I'm sorry. 16/11. 16/11. Then the page 35 is the third. It is again retender.
In the third retender, you were all disqualified.
Yes.
You were all disqualified in the third retender.
No, it is second one.
Second, in the
Correct.
second, you were all disqualified.
All disqualified. It is the third, Lordship. It was open. And then my client in the technical bid was, Lordship, that is at page 65. Lordship. Page 65 onwards.
9/1/24.
Yes. Lordship,
So there
here,
were only two valid bidders.
yes. At page 68, Lordship will take note. After scrutiny, all the bidders as stated above. Page 68.
Yes,
After scrutiny, all the bidders as stated above were found to be technically qualified as the tender was called for the third time. The note is very clear, Lordship. As the tender was called for the third time, the committee members have decided to open the financial bid on 22/2024 at 2 p.m.
correct, so it was open,
Lordship.
it was open,
Yes, then it was open, Lordship.
yes,
That document I have shown, Lordship. And they have seen the price and here, my client was the highest bidder, Lordship. The L1. Then Lordship at,
so so when was it open?
yes, Lordship, the document shows it was on 11 March 2024, Lordship. We have downloaded, Lordship. It is 12 February 2024. It is, Lordship, the date is, Lordship, it is not there, but it is when submitted and all that, it is open on the date. Date is not there. In the, my document.
Then from where did you get 12 to 24?
Lordship.
Then from where did you get that date, 12 to 24?
In the, yeah, Lordship, Assam government, that website, Lordship. The submission date is there, Lordship. Third column, Lordship, in the bottom. 12 February.
Bid
Yes.
submit date and time, this
Yes.
bid submission.
Bid submit.
So that, the bid submission is what, is it bid submission, is it the date of
It
opening
is
of
a
the financial?
technical bid, technical bid and the financial.
No, but financial bid was opened subsequently.
It is open, Lordship, this last column, Lordship. Financial bid. Opening time. Date opening time, bid opening, date and time is on the top, Lordship. Bid opening, date and time, 20th February, 2 p.m. Lordship, here, Lordship.
But no, bid opening is with regard to
Technical bid.
technical bid.
No, technical bid, long back it is open,
No,
Lordship.
let us see again that page,
Yes,
page 68.
65. Page 65, Lordship. It was the opened on minutes of tender bid opening so and so on 9/1/24, page 65.
Minutes of tender bid opening meeting held on 12 to 24. 12 to 24.
Yes, published by so and so, they have signed. Then after the year, Lordship, it was decided.
No, but how, where was it open? It was, you see, this thing is of 12 to 24. Meeting minutes.
Yes. In the last part, 68, they have decided.
They have said that we found technically qualified.
Yes.
So this. So.
And they have decided, the members have decided to open the financial bid on 20/2/24 at 2 p.m. And the time of opening and the date is there. At 2 p.m. they have opened on 28th February.
Okay. So technical bid was open on 12 to.
12/2.
Yes.
12/2/24. Technical bid was
Financial
open.
bid open, okay, then.
And they have decided to open the financial bid on 20/2/24. 2 p.m.
Yes.
And accordingly, it was open.
So they have opened, then.
Then Lordship next, Lordship, please come to page 70. It is the fourth tender now they have opened for the same one. after opening my financial book.
Dated
On 8/3/24.
eight, 3/24.
Yes. Lordship, at page 76, I have annexed the Central Vigilance Commission's here guideline. That is very clear, Lordship, Central Vigilance Commission guideline. At page 87. So it is started at page 76, Lordship, Annexure 14. CBC guideline.
Yes,
Page 76, Annexure 14.
yes,
And Lordship, at page 87,
yes,
clause 10,
yes,
10.1, there are bullet point, Lordship.
yes,
And in the last but 3, Lordship, ensuring that the L1 is not ignored on any flimsy ground. Specific, Lordship.
okay,
And
then,
that is open 3 times, Lordship. Second time only, Lordship, is very correct. They have rejected all. First time, my technical bit was correct. What they said, that there is only one tenderer. First time. First year. Now, Lordship, for that also, Lordship, may please come at page 94, Annexure 15.
yes,
At serial number 3.
yes,
As per existing guideline of CBC, the single tenderer can only be accepted subject to recording the details as stated. There was 2 tenderers, then one bid was rejected. So they said that I am single. I am not single, Lordship. There's 2 tenderers.
1 o'clock
Lunch.
lunch.
15 minutes time, I have to move an application with code number 19.
You see, at 2 o'clock, we have fixed Mr. PK Goswami, all those big ones. So if they start, you will not have chance. You have got to be here too.
I do it.
No, you have to be here. That will take the whole day. That will not even finish. So since we have started this, we'll finish this.
That is one of the. Otherwise, any day, my lord.
Anyway, let us see whether they will take adjournment. I don't know.
No, he's ready.
They might take adjournment also, we don't know.
No, he is ready. So we say the item number.
No, he's not the only one. They have got 2 other seniors also who have to.
No, but the item.
It has to be, and it is not his turn to argue also. It is somebody else.
So Lordship will give me 15 minutes buffer time, Lordship. I'm sitting here from the morning, Lordship. Please stay for me.
Kindly pass over for time being. Is it port number 19?
Huh?
Is it port number 19, Marcel?
19th.
Only thing in item number 6, it is 6 on 20th. One line if it is added, then well, by that time bidding should be completed by the parties. Because I find
Item
6.
Item 6, you're right. Item 6, in the meantime, bidding should be completed by the parties. No, this item is what item?
Yes, my lord, service report is incomplete against respondent number 7. And the Lavazima court, my lord, directed us on 6/5/2025.
We have not taken fresh step.
Let me take first step, my lord.
Huh?
Let me take first step, my lord. And my lord, in that then respondent may also file their affidavit. Instruction, Lord, sir.
Have you obtained?
No, sir, I am awaiting instruction.
Okay, right. In terms of the Lavazima court order dated 6/5/2025, the petitioner is to take fresh steps for service of notice upon the respondent number 7. Mr.
You get it.
UK Das, learned counsel for the petitioners, submits that he will take 5 steps within 2 days. Leaves the matter after 2 weeks. In the meantime, Mr.
AI Ali.
AI Ali appearing for
Response number 2, 4 and 6.
2, 4 and 6 and Mr.
Each of the comment.
B.
Each of the.
B Chanda for
That's what 3 and 5.
3 and 5. Shall submit their affidavit.
We have concluded our argument. No,
Really?
Your Lordship asked me to give a PPR written notes. We have also prepared it.
Okay.
All the things were two judgments that I would like to place. Whether the proceeding under say, Rule 25 is a summary proceeding or not. On the long back, I told your Lordship that is a summary proceeding.
No, you
But
see
on
the
that day-
problem, you see the problem with this matter is I'm hearing it in fits and starts, I mean in pieces. And I don't remember what is where, who is.
So for that reason, we have prepared our written
But
argument.
you have not put that, you put that in the written argument. Please put in your case law also.
Yes.
It's there.
Oh, all this.
That with regard to
Ah.
whether it is a summary
Yes,
proceeding or that.
Yes. Summary proceeding, I can give the judgment also here also, additionally. If there is no procedure have been laid down, then it will be presumed that it is a summary proceeding.
Procedure laid down for coming to
Okay, conclusion.
conclusion with regard to the pay.
With regard to any quasi judicial proceeding,
Oh,
quasi judicial proceeding, then it should be considered as a summary proceeding. That is 1995, let's see, Supreme Court paragraph 13.
Mohanlal,
Yes.
Para?
13.
13.
13.
Yes.
And this judgment was relied upon by the subsequent case by the Honorable the Shaikh. That is also happened here.
Para?
It is also 13. At the very beginning, there I argued that this is a summary proceeding, but on that day, your Lordship asked me of how you can say a proceeding. I could not satisfy your Lordship. Long back when I came. Then
Long back, I don't remember
No,
so
yes,
many cases.
whatever, let us forget all these things. But subsequently, I have found out. So, I can give the written argument also. Maybe if your Lordship is there.
Yes.
My friend is to argue that. Thank you. He has also prepared a note. Central government.
For whom?
Yeah.
1 and 2. So you are supporting whom? You have not given the paragraphs. Only for the first case you have given the paragraph. No other choice now. My God. Your written arguments are like your petition only.
No, Lord, in this, two judgments are there.
That is not the issue. I told you to make a small point wise. Otherwise, I mean, as good as reading your affidavit. How many pages is this? 20, how many? 20? 23.
I can give it. Follow.
Give me a gist. I mean, don't make it.
All right, then I shall give it. Two pages or 3 pages.
Yes.
All right.
Point wise.
All right.
Point wise.
All right.
And look at the judgments.
Judgments below folders. Separate folders. All right.
Not tomorrow. Tomorrow I've got
No, you just give it to you.
there's other matter also, na. I've got to hit two matters simultaneously. I've got to decide it. Give it to one. No. Yes, you finished? No, you're still doing it.
Also, was waiting to receive theirs to give ours because
Huh?
my friend was waiting
Okay.
get them to give your lordship.
To take care of his submissions.
Yes,
Reverse. Here it is reverse. Generally, in the
Ah.
like on the petition.
So they are being smart.
They are being smart.
No, I have already
Deliver-
done.
Deliberately about it.
No, I have already done. You have partly already done, now you are giving, so we will see and then give a reply.
He wants to give written naturally.
Uh,
I need written because I don't now this matter
quite
is a
soon because
difficult.
I have forgotten myself, so I can understand the
Yeah,
lordship's
lordship, yeah.
comments. To be very
Nature
frank.
has blood. Lordship says,
Because I don't do cases like this.
Ah,
I don't hear and then have another date and then have a.
I quite follow.
I don't usually do. I don't follow this procedure.
So let them give that and we will give a little note and I will address.
What we will do is
Alright.
you give him a copy.
Yes,
And
right
you
now
give him a copy and you give me a point form. Don't be in a hurry. I don't want it to be done in a hurry that it should be, the point should be solid. How it should be developed is already there in your affidavit. How you, and in your submission. But what is your main point? Like you say, like it is a non-joined necessary party or fraud or, those aspects
Point
or
wise.
this, yes, one line sentence or two line sentence, two line sentence. Or, small, two sentences, one point should not be more than 2, 3 sentences at the most.
I have to extract it from this argument.
How you extract it from there? What is the heading? I will develop the rest as I see it.
That will be better.
I will enter it from
To
my
us also,
Ah.
we'll also give a reply to that and then orally you can finish this.
Because I will hear you all after I read all that.
Yes.
I will hear you all and we'll make it short and then try to finish it off.
So, thought, things you can give us, we'll also give you. And then,
Actually, why I insisted for today, this matter, the reason was I thought I was supposed to have a hernia operation tomorrow. So I thought then I'll be in bed doing nothing for at least 3-4 days. At that time I could finish off your case.
no, it is good, your
Ah.
lordship should take place.
Fortunately or unfortunately for me, the doctor I went to him day before. Again, for final preparation. So I checked me physically, he said, I'm not finding the hernia anymore.
Oh, good, good, that is great.
No, that is great, but the problem is now that free time that I thought I would have, that has gone for a 6.
I think we should schedule on that because my third matter I just left because I
Ah.
didn't want to tell her what. So I'll go back and finish that.
You do that, and then you give me the thing. Now because I'm going to be busy from tomorrow. I've got one tribunal matter. I've got to pass the order by 22nd of this month.
So they can give us and we'll exchange our short notes
Ah,
and
ah.
give it to your lordship. And
We fix a date.
I give my written argument to him,
First week of June. First week of June. No, it's not possible. Fifth.
So we shall furnish additional supplementary notes from the written argument in brief.
You make it supplementary. This I will keep. You make it supplementary.
Gist, whether it's.
Gist, point form. Point form. Like your basic case is that the
Summary proceeding.
yes, the law and everything. Point form. The law also point form. Correct. What about Mr. Das's matter? That has to be heard separately. BD Das?
Same thing, we'll finish together.
Okay. Right. Here. Next date. Okay, right. Mr. A. Das Gupta, then a senior counsel for the respondent number 3. And Mr. G. Pegu for the respondent number 1 and 2 have both submitted written arguments. So they also submit that they will, Mr. A. Das Gupta will also submit a gist of his arguments as gist of his arguments with a copy being served to the other side. And this is a matter on 5th, on which date the petitioner shall submit their written argument. This is the matter.
An argument and also orally I will.
That no need to mention. We'll do that.
That will be better.
That depends on your lordship's query.
Correct.
So if your lordship goes through the written argument, there's some gray area, then it will then accept.
That's Thursday. Okay. 5th June at 2 p.m. Okay.
At 2 p.m.
This agenda can be passed for the day.
Okay, right. On the pair of Mr. A. Das Gupta, then a senior counsel for the petitioner, the matter is adjourned for 2 weeks. Mr. K. Kalita appears for the response. Again, same tribunal.
No, that's basically short matter. That-
Short matter, but he's got a good case, or what?
Yes, yes, why? This is yes. A good case for. No, no, I don't think.
My lord, the other side is not.
Huh?
Our side is not.
What is your case?
Yes, my lord, what is this in this particular?
It is for electricity bill. What is this?
Electricity bill.
Electricity bill, and then
And that electricity bill is time barred. And they cannot elect you more, my lord, and for that particular purpose.
and what has happened to your company?
A company, my lord, it has always been struck on.
Then
Because it means by two of the provisions of section 248 of the Companies Act, man. If you look
Yes.
at take us. So,
He's on his field.
that means his name has been removed. from
just
the-
a minute. Yes, which is the document under challenge?
That is your lordship is fine. The supplementary bill, that is that
Page?
at page 22. Further, the letter that is 55 2000 at page 5.
Page 22.
22. 22,
82?
20, 22.
A bill dated
It is the date that is 21/11/2014.
for an amount of rupees 24
At
64
people
two. Now, what is the ground for challenge?
My lord, under section 56 of the Electricity Act.
50, just a minute, this bill is for which period?
That is-
21/6/7
Yeah.
to
21/6/7 to
36/14.
1/11/12.
Huh? 32
21/6/7
to
to
1
1/11/12. This is
1
time bar.
11 12. And also
Also for
22/4/13.
36/14. And so far,
36/14.
second period is concerned, I am liable to pay it.
Okay. Second period, you are liable. First
For the
period
first
is time bar.
I am not liable.
Okay.
And for that particular purpose, first
So
particular,
have you paid the second, the bill for the second period?
because the stay was granted by the honorable court,
No, but
and
then,
I paid at the initial instance 2 lakhs as per the direction of the honorable court.
but how, what is the, for the first period, your bill is 377,924.
Yes, 1/11/12.
Huh?
21/6/7 to 1/11/12. For this period, I am not liable to pay under section 250.
So let us go to page 22 of the writ petition.
Yes, ma'am.
So according to him, this bill is for two periods. One is for 21/6/7 to 1/11/12. Have you got it?
Yes.
And the second period is from 22/4/13 to 30/06/14. Correct?
Yes, it's a continuous period otherwise. It is from 20.
It is not continuous. How can it be continuous?
My lords, the period is 21/06/2007.
Yes. To 1/11/12.
We clarified this in our affidavit.
You've clarified it.
Yes, my lord. Before this, my lords, if my lord sees the last two orders, what are taken in objection, my lords, as on today, the petitioner company has ceased to exist. They've been struck out. And my lords are aware, my lords, a private limited company is a distinct separate juristic entity, which is under the roster of the registrar of the registrar of companies. My lord. The company has been struck out. So as on today, it does not exist. They cannot possibly maintain the petition.
Then who is going to pay?
So that is subject to what lordship
No,
said.
no,
Further point,
no, you see. Okay, the company is say non-existent. So then what happens to your bill?
we'll have to recover it in some other manner.
From who?
We'll have to go after the persons who are holding the office or the directors to their personal assets or something like that. But as on today, my lords, can they possibly maintain this writ petition? And my lord will see that the last AGM and the last balance sheet was filed way back in 2013. The company has ceased to exist thereafter.
Okay,
This is a rate of 2015, my lords.
okay, their company ceased to exist from when?
That detail is not there, my lords. I have tried checking. But my lords,
When did your company cease to exist?
and they were directed to get the
Sometimes in the year of 2013, exact date I didn't.
Then how did you file the writ petition?
Yes, madam, by virtue of section 240 of the company.
Section 240.
248. As well as my lord. Section 250.
250 of the
company.
Let us see. 248. There?
My lord, 248, have you got it, madam?
Yes, yes.
Where the registrar has reasonable cause to believe that. My lord,
Have you got a copy? Have you got the second copy of this company there? Give it to the council, APDCL council.
My lord, directly I am taking to your lordship without taking much more time of this honorable court. To subsection 5. 248, that is the power of the
Yeah.
5. At the expiry of the time mentioned in the notice, the registrar may arrange post to the contrary form by the company, strike off its name from the register of company, themselves published on the thereof in the official gazette, and on publication in the official gazette of this notice, the company is listed.
So?
Now your lordship will come to 6.
that the registrar before passing an order, let's say, subsection 5, shall satisfy himself that sufficient provision has been made for the realization of all amount due to the company and for the payment of discharge of its liabilities and obligations by the company within a reasonable time, if necessary, obtain necessary undertaking from managing director or other person in charge of the management of the company, provided that notwithstanding the undertakings referred to in this subsection, the assets of the company shall be made available for the payment and discharge of all its liabilities and obligations even after the date of the order, removing the name of the company from the account. Now, my lord, 7 is very important. The liability, even, here is the liability, my lord, even of every director, manager, or other officer who were exercising any power of management and of every member of the company resolved under subsection 5 shall continue and may be imposed as if the company had not been dissolved. So, this being the position, my lord, the petition is noted. Apart from it, my lord, your lordship will come to section 50, 250. Effect of company notified as dissolved. Where a company is still dissolved under section 248, is shall on and from the date mentioned in the document. Under subsection 5 of that section, CJ to operate as a company and the certificate for shall be deemed to have retail site from such a date, except for the purpose of realizing the amount due to the company and for payment of discharge of the liability obligation of the company. That being the position, my lord, this is pretty. Because I have to discharge in every.
Okay, then carry on.
So that being the position, my lord, it is maintainable. And I have the locus to maintain it.
Now, page 22 is the bill that is put to challenge. Now, 22 talks of 21/6 to 2007 to 1/11/2012. So this is a period of approximately,
If we take the two periods together, madam, this is a period from 21/6/2017, which there is a gap thereafter and it goes up to 30th June 2014.
yes,
Yes, madam. The additional bill or the supplementary demand was raised for the reasons which is we've explained in our affidavit. So, my lord, can you?
which is the supplementary demand?
This is the supplementary. Demand.
Which one? This
This bill
page
itself.
22.
Yes, ma'am.
You see, one thing he has basically said is that this second period, 22/4/13 to 30/06/14, this he is liable to pay. But the earlier period, this is hit by limitation. So that,
Yes.
so that is, now is that your case?
Yes.
That, so if that is the case,
My lord,
You-
this matter is covered by the judgment of the Honorable Court.
whatever it is. Now, if that be the case, if you are admitting that you are liable to pay the electricity assessed for the second period, you pay that amount.
Yes, I am ready, my lord. 2 lakhs I have already paid at the time of granting the.
Why didn't you pay then interest?
Remaining, I am ready to pay because.
No, you should have paid it then if you were liable. Why?
If your lordship direct to that extent and because of the disputation, I am ready to pay.
Okay, now the first part. This
As far as the first part goes, madam, and senior friend, allow me. As the limitation issue that he's raised, and he's referring to 56(2) of the Electricity Act, madam. That provision has been settled, that provision of law has been settled by the Supreme Court. The Supreme Court has held that the liability to pay will occur at the time of consumption, but the obligation to pay will only arise moment a bill is served by the licensee to the consumer. In fact, my lord, there are judgments of our Honorable Court as well as the Honorable Supreme Court. May I place them?
My lord, before we argue, Yeah, wait, I'm placing the judgment of the Supreme Court, my lord. So that, judgment, yeah, yes. It's a motion, yes, sir. My lord, 2024 SEC is 650.
2024,
2020, volume 4, SEC is 650. And for this particular first role, my lord, I'm taking to your office to para one of the.
para one.
Yeah. May I read it, my lord?
Yes.
The issues which have been arising for consideration in the present civil action are, what is the meaning?
The issue,
Yes.
it is the factual matter. Para one, you said.
Yes, para one.
Para one starts with the factual matter.
No, from very beginning, sir, prior to para one. From
Prior to para one.
yeah.
Prior to para one, there is nothing. Delay, condone, leave,
Delay
granted.
condone later on, my lord. A, the issue which has been arising for consideration.
Okay, this is not para one.
Yes, sir, sorry, ma'am. Yes. Now, what is the meaning to be ascribed to the term first due in section 56(2) of the Electricity Act 2003? In the case of a wrong billing bill having been applied on account of a mistake, when would amount to become first due?
No, look, one thing I want to first clear. Are you challenging the amount that has been billed? You're not challenging the amount.
Note, I'm not challenging the amount, but.
Saying that it is delayed, it's hit by
Yeah.
limitation, that's all, correct?
So that my lord, this point has been decided, and prior to coming to it, my.
Because it says in case of a wrong billing, correct? So there is not a case of wrong billing, it is only a case of whether it is hit by limitation,
These are the points think by the honorable Supreme Court.
depending upon the fact of that case.
Yes, but the first point is very important, that because the first become due,
Yes,
that is the
yes.
crux of the matter, my
Let
lord,
us
in
see.
this particular case. My lord, for this particular purpose, my lord, may I take your lordship directly to para 6(2). Para 6(2).
Yes,
The purchase civil appeal pertains to the interpretation of section 56 of the Act, which is as follows. I'm skipping over it, my lord. Now your lordship will see section sub 6(3). The obligation of a consumer to pay electricity charges arises after the bill is issued by the licensing company. The bill sets out the time within which the charges are to be paid. If the consumer fails to pay the charges within the stipulated period, they get carried forward to the next bill as area. The provision of the interpretation carries out an exception by providing that the disconnection will not be effective if the consumer either deposits the amount under protest or deposits the area charges paid within the preceding 6 months. Subsection 2 by a non-obstant clause.
which one, subsection?
Subsection 2
Ah,
of section 56 by a non-obstant clause provides that notwithstanding anything contained in the law for the writing in court, no sum due from the consumer shall be recovered and the check after the expiry of 2 years from the date when the sum becomes first due, unless such sum was found continuously in the current aggregate of charges for the electricity supply, nor would the licensing company disconnect the electricity supply to the consumer. Now, my lord, your lordship is see. Next one. I'm skipping over the next one, madam. Now you're going to see 6(6). The liability to pay arises on the consumption of electricity, the obligation to pay for the right benefit issued by the licensee and qualifying the charges to be paid. Electricity charges would become first due only after the bill is issued to the consumer, even though the liability to pay may arise on the consumption of electricity. Now, my lord, your lordship will see the last line in this paragraph. The standing committee further opined that a restriction had been added for recovery for areas pertaining to the period prior to 2 years from consumer, unless the areas have been considered for in detail. Justifying the addition of this statement is to found committed that it has been considered necessary to follow such a restriction to protect the consumer from arbitrary delay. Now, my lord, section 7, my lord, 7, 7.2, my lord. It would be clear that the right to recover the charges is one part of it, and right to disconnect supply of electricity energy to consumers who neglect to pay charges is another part of it. Subsection 1 confers explicit right to the licensing company.
How is this
Regarding the first due, when it became the first due.
First due becomes, it becomes due after the bill is issued. That's all.
No, on 21,7, my lord. This has been clarified in this judgment.
Huh?
My lord, your lordship make up. Section 8.
Yes.
Para 8. Section 52, however, does not preclude the licensing company of raising the supplementary demand after the expiry of the limitation period of 2 years. It only restricts the right of the licensing business to that due to non-payment fees after the period of limitation of 2 years has expired. Nor does it restrict other modes of delivery by the license. My lord, it has been decided in this case that the first, when it becomes.
Does not preclude the license from raising a supplementary demand after the expiry of limitation period of 2 years. It only restricts the right of the licensee to disconnect the electricity. The supply due to non-payment of dues after the period of 2 years expired. Not does it restrict other more. No, it only restricts the right of the licensee to disconnect the electricity, nothing else.
Yes. What I require, so far the liability is concerned, that is a different part, man.
Correct.
Let them go to realize it. I am not upon that one. They cannot disconnect. That my report, I will not disconnect. We will not disconnect.
No, they will not disconnect.
Okay, we are also relying upon the very same judgment. If they are not going to disconnect, in that case, my petition may kindly be allowed. That only for the non-payment of due, they cannot disconnect. That is my prayer, my lord. That is also the prayer, my lord. In my reading.
But you have not paid your dues till now.
Yes, my lord, stay was granted by this.
Stay was granted, but then they could not, they could not have been a stay because Limitation Act is not applicable.
Yes, sir.
This 52, this 56 is only to restrain the APDCL from discontinuing the electricity supply. That's all, nothing beyond that.
Yes. Beyond.
So you have misguided the court properly.
No, my lord, that is my case. If your lordship will go through, I am the last person to misguide the honorable court, my lord. At none of the occasions in past, I misguided the court.
Okay, so why did you file this case?
Yes, my lord, because.
So you were scared of the disconnection of electricity?
Yes, lordship will come.
So you were scared of the disconnection of electricity?
Yes, my lord.
Let us see your prayer.
Now, my lord, your lordship will come. At page 28.
No, just a minute. Let me see your prayer.
They're seeking setting aside of the bill.
Yes.
Huh?
They're seeking setting aside of that very bill.
That's what I wanted to know. The which was the why?
Page.
NS, should not be quashed. It is nothing to do with disconnection of electricity.
My lord, second your notice will come at page 20 of my petition.
Why shouldn't you pay interest on the bill?
My lord, that is a different thing whether they can revise the amount or not, my lord. Due
What?
to the limiting.
If it is, if it is, you have not paid your bill for so long on the basis of a stay order passed by this court. This
Yes.
case is of 2015.
15. And my lord, your lordship will come to page 28.
Yes.
But till now, no payment has been done. Second paragraph. But till now, no payment has been done against the above. You are hereby to make a billing Sunday from the images we are telling you the power supply to your business is extended. And that is the reason I have challenged both our this letter to I have challenged by this.
On what ground have you challenged?
Oh,
That it is a fabric, it is not correct bill or what?
no, it may be the correct.
Then?
But for non-payment of dues pertaining to the earlier period, prior to 2 years, they cannot disconnect the supply.
No, that is
That
not
is
your
not-
case. That is not your prayer.
That is.
Where have
clear.
you said? Let us
Your
see.
lordship will come.
Let me read your petition.
Yes.
Let me see. Anyway, who has
Should not keep one. The second one. Though I have paid for quashing the assessment bill, apart from it, I have also challenged the validity of this letter, 15/5/2015.
There was a disconnection notice issued to you.
Yes, that is the one.
Page
At
28.
page 28. That they would disconnect it in
Okay.
7 days. And I have challenged the validity of that letter, that they cannot disconnect for non-pay.
But you have not challenged this order. Page 30, page
Yes.
28.
28, I have challenged my
No,
15/5/2005.
that this letter is of 30/01/2015.
I have challenged the letter dated 15.
15/5/2015 is a different letter. The disconnection notice you have not challenged.
Just a minute.
Okay,
F,
15/5 also you have challenged.
Yes.
Because, but this is only because you have not paid.
Eh,
55.
15/5/2015, my lords. Your line will be without.
Anyway, so he has to pay, that's all. You don't disconnect his electricity, that's all.
That the judgment itself is, there is a directive, I will not disconnect, I will report that. As far as the liability goes, my lord, the liability remains.
Liability
Yes,
remains, he is not
liability,
challenged, he is also not challenged. His only grievance is that since the bill pertains to a period beyond 2 years, now the threat of disconnection of electricity cannot be made by you.
And they can
That's all.
recover the amount by any mode available.
How are you going to recover? How are you going to pay?
My lord, I think that was my lord time bar, it is time bar under limitation act. Accordingly, my liability does not arise, man.
No, then my lord, sir, will hear me then.
Yes. What do you mean? What do you mean is time bar? What is time bar?
Electricity,
Bill? No.
no, the prior huge.
No, that is also not time bar. How is it time bar? Show me. Show me how it is time bar.
Yes, my lord.
It is not time bar.
It is not time bar, let them relax.
No,
by
you
any other-
you see, Mr. Counsel,
Yes,
you said it is time barred. So this court is asking you.
Yeah.
How is it time barred? Which provision
My
says it is
lord.
time barred?
yes, my lord. For that one, my lord, I have to take your lordship to the petition act. After the 2 years, after the 3 expiry of the 3.
Take me anywhere you want. Take me anywhere you want. I'm ready.
My lord, for that particular, let it become day after.
No adjournment. Adjournment denied.
Because
No, I'm not
Because
adjourning.
This limitation. period
Sorry,
for
sorry,
recovery-
sorry. I'm not
for
adjourning.
recovery,
Sorry.
it
This
will
matter is
only
a
be
2000,
3 years.
sorry. Yes.
It-
Mr. Chairman, but you please sit down. You don't have anything to say. Sit down.
Very same judgment, my lord.
I know, I think I passed.
Yes, my lord. Yes, my lord. There is an order of my lord.
I think I passed also order a long time back with regard to this.
The
It's a
CC
system.
online copy, my lords.
Yes,
Para 6.5 of this judgment, my lord.
6 point, the same thing that is
Yes,
given.
it's a SCC online copy.
Para 6.5, yes.
The obligation of a consumer to pay electricity charges.
Just a minute, para 6.5.
Yes, my lord. The obligation
Yes,
of a consumer to pay electricity charges arises after the bill is issued by the licensee company. The bill sets out the time within which the charges are to be paid. If the consumer fails to pay the charges within the stipulated period, they get carried forward to
to the next
bill
bill,
this area.
correct.
And my lord, can you hear me, my lord? 6.9, my lord, thereafter.
Yes,
The liability, this is important, my lord. The
Yes.
liability to pay arises on the consumption of electricity. The obligation to pay would arise when the bill is issued by the licensee company, quantifying the charges to be paid. Electricity charges would become first due only after the bill is issued to the consumer, even though the liability to pay may arise on the consumption of the electricity. Now, my lord, para 7.5, my lord. 7.5 will take care of his argument with regard to limitation, my lord.
yes.
The period of limitation of 2 years would commence from the date on which the electricity charges become first due under subsection 2 of section 56. Manoj will recall, they say the Honorable Supreme Court has said it will become first due when the bill is served.
Correct.
So the 2002-year period will commence from the date. the
It
bill
is served.
Yes,
It is- yes.
yes, ma'am. This provision restricts the right of the licensee company to disconnect electricity supply due to non-payment of dues by the consumer unless such sum has been shown continuously to be recoverable as areas of electricity supply in the bills raised for the past period. If the licensee company were to be allowed to disconnect electricity supply after the expiry of the limitation period of 2 years, after the first sum became first due, it would defeat the object of 56(2). Manoj, I am bowing down to that, Manoj, we cannot possibly disconnect. Now, as far as supplementary demand is concerned, Manoj, our cases, there is a multiplying factor that is putting on, as far as commercial consumers are concerned, there is a multiplying factor depending upon their consumption. Now, here what had happened was the multiplying factor that was supposed to be part of every calculation or the bill that was to be presented to the petitioner was supposed to be 15. That is not, they have not even disputed that.
What? The
The
multiplier
multiplying
factor?
factor ought to have been 15. APDCL
1.5.
1.5. APDCL
1.5 for what?
1.5.
For what? For
It is
multiplying
a
factor?
multiplying
For
factor.
delay?
No, man. For
For
commercial-
calculating.
Yes, for calculating the
yes.
consumption. Now, for the period in question, admittedly, my lords, what inadvertently the APDCL had applied the multiplying factor of 1
Oh
instead
my
of
God.
15.
Okay.
So that is why the supplementary demand has been used.
Okay.
Now, 8 will take care of that addition, that supplementary demand. Also.
Yes.
Para 8. Section 56(2), however, does not preclude the licensee company from raising a supplementary demand after the expiry of the limitation period of 2 years. It only restricts the right of the licensee to disconnect.
Correct.
electricity supply.
Only that. It
Yes.
only restricts that.
Yeah. And
There is no question of there being delay for payment.
My lord, for this particular purpose, may I take your receipt to the last of this case matter? That is, there are 9 last one.
Yes.
In the present case, the period of limitation commences from the date of dispute will take a certain time. The licensing company may take recourse to any remedy available in law for recovery of the additional demand, but it's barred from taking recourse.
Correct. Disconnection to it will not be done.
And according to that,
Yes.
Yeah,
Only disconnection of electricity cannot be done, but you have got to pay the entire amount within 1 month. No, I will give. No.
that I am liable to pay.
No, I will give that direction. You have not paid your dues, admitted dues, in fact, for the last 10 years on the basis of a stay order. Stay order for disconnection should have been given. It should have been clarified. You could have asked for a clarification also. Well, you did not ask for a clarification. Okay, right. A small issue this case. Nothing. I heard Mr. O.P. Bhatti, learned counsel for the petition. Also heard Mr. B. Chowdhury for the APDC. Standing counsel APDC. The petitioner has the petitioner being aggrieved by the I got so many judgments they're putting here. I can't even turn to the main thing. They let it be removed. It's so I don't need any of these judgments. Uh, the petitioner is aggrieved with the letter dated 22/11/2014 issued by the respondent number 3 to the petitioner, by which a supplementary bill amounting to rupees 24,64,222 for the period with effect from 21/6/2007 to 30/06/2014 has been served upon the petitioner So this page 22 is the supplementary bill.
Yes, ma'am.
Come on, in as much as the energy bill served upon the petitioner earlier for the above said period had been calculated with the multiplying factor of 1. And the same had been corrected by way of the supplementary bill by using the correct multiplier factor of 50. That's fine. The petitioner has also, the petitioner has also put to challenge the letter dated 15/5/2015 issued by the respondent number. This is an impugned letter, both are impugned. Impugned letter dated 15/5/2015 issued by the respondent number 5. Which dismissed the petitioner's appeal No, which rejected the petitioner's appeal for dismissing the supplementary bill. Pusta. Next paragraph. The petitioner's case in brief is that the petitioner had been issued a supplementary bill dated 21/11/2014 for paying electricity bill amounting to 24,64,221. Is it 221? No, 220. 222. 222. 222. Huh? 222. The supplementary bill was for payment of electricity for two periods, that is from 21/6/2007 to 1/11/2012, and from 22/4/2013 to 30/06/2014. Next paragraph. The petitioner's counsel submits that the supplementary bill pertaining to the first period, that is 21/6/2007 to 1/11/2012, is hit by Section 56(2) of the Electricity Act 2003. Is it? Electricity Act 2003, and as the same assessment for electricity has been issued 2 years after the period of consumption of electricity. Full stop. He submits that the petitioner, however, is liable to pay the electricity bill in terms of the supplementary bill for the second period, that is from 22/4/2013 to 30/06/2014. Full stop. The counsel for the petitioner submits that in terms of the judgment of the Supreme Court in the case of assistant engineer, bracket DI, D1, right close, comma, Ajmer Vidyut Vitran Nigam Limited and another versus Rahamatullah Khan alias Raham Julia, reported in 2024 SCC 650. The Supreme Court had held that in terms of subsection 2 of section 56 of the Electricity Act, comma, after no sum due from any consumer shall be recoverable under section 56, comma, after the expiry of 2 years from the date when the sum became first due, inverted commas, first due, comma, unless such sum was shown continuously recoverable as arrears of charges for the electricity supplied, comma, nor would the licensee company disconnect the supply of the consumer. Full stop. He also submits that in terms of I think that's the entire case, nothing mixed. The Mr. G. B. Chowdhury, the learned counsel for the APDCL, come on the other hand, submits that there, the Supreme Court in the above case of Rahamatullah Khan, Supra, Rahamatullah Khan alias Raham Jula alias has clearly defined has clearly defined has clarified as to when the electricity charges would become first due, invert commas, first due. That first due to mean that it would become due only after the bill is issued to the consumer. Even though the liability to pay may arise on the consumption of electricity. Further, the period of limitation of 2 years would commence from the date on which the electricity charges became first due under subsection 2 of section 56 of the Electricity Act. In the present case, the supplementary bill had been issued only on 21/11/2014. And as the writ petition had been filed on 25/5/2015, there was no question of the supplementary bill being hit by section 56(2). In any event, he said the Standing Council APDCL submits that in any event, section 56(2) is not with regard to limitation being imposed on the payment of electricity bills, but only with regard to discontinuation of electricity to the consumer if the bills are not given to the petitioner. Now, if the payment for the bills is not made by the consumer within 2 years after the electricity charges became inverted commas first due. So that is the thing, correct? He accordingly submits that the learned counsel for the petitioner has to pay the bills to the petition as per the supplementary bill. But what about the electricity disconnection earlier part from earlier part?
There's no disconnection.
No, so actually, could disconnection be made because supplementary bill was 2014? Because the earlier part,
Period of consumption is beyond the 2-year period.
Ah.
So we can recover the dues, but we cannot possibly take recourse to 56(2) for
No, but then the first due comes into play only when the charges are made known to them.
Yes. But
Not
the
the-
period of consumption, if that is beyond 2 years,
What does the Supreme Court say with regard to that?
7.5.
The period of limitation would commence from the date on which the electricity charges became first due. It's not from the date of consumption. It's from the date when it became first due.
First due.
So first due would be from the date when the charges were made known to the consumer.
See, recovery is not prohibited. What
Ah.
is prohibited is disconnection.
Correct.
7.5.
But then it's not, you do not count it from the date of consumption. You count it from the date of the charges being made known to the consumer. Isn't it, Mr.?
It was not being continuously.
Is it correct?
My lord,
7.5 will probably explain the situation. Para 7.5.
because first it became due on 21/6/2007.
No.
7.5, if I may.
No, yes.
Continue.
No, we see, no, what I am asking you this, probably it became due first due because actually you had made a demand under the for multiplier of 1 in 2007-8 probably you would have made. You should have made it under 15. It was a mistake on your part.
Yes.
So the charge, the bills that were submitted to him in 2007-8, you see, at that time, it became due. It became due. Okay, it may be a wrong bill, but still it became due then. So that's why that you cannot disconnect. So stop. Next paragraph. No, continue right. The Standing Council for the APDCL submits that in view of the period of limitation having commenced at the time of submission of at the time the consumer was made known of the electricity charges as per the multiplier by the multiplying factor.
That's slightly different, subject to a lot.
Yes.
7.5 explains the situation.
Yes.
The period of limitation of 2 years would commence from the date on which the electricity charges became first due under subsection 2 of section 56. Thereafter, this provision restricts the right of the licensee to disconnect electric supply due to non-payment of dues by the consumer unless such sum has been shown continuously to be recoverable as areas. Here, my lords, we had served him bills under the multiplying factor of 1.
Correct, that's what.
That is, we've not shown the amounts as continuously due because we applied the wrong multiplying factor. Moment we discovered it, it was beyond the 2-year period. Hence, we cannot possibly take recourse to the coercive action.
No, this disconnection
Yes.
has to be counted from the date of consumption? No, I don't think so.
No.
From the date the bills were made known to you. So this is the bills were made known to him
And
earlier wrongly. So as per this, you could have disconnected.
yes. Perhaps. Now,
Perhaps, but then but of course, if you go say, if there was no mistake, say in 2007, say the multiplier was correctly used, it was not 15. If it was 1, then you could not disconnect. But this is a different issue.
Now, this is in the form of a supplementary demand. And probably that is why the Supreme Court went on to say that you can.
Anyway, let me not go into that.
Yes.
I will just go into the issue of whether the limitation, whether the limitation period provided here would relate to payment of bills and not with regard to discontinuing the electricity supply. That's all.
I record my submission. The APDCL will not disconnect.
Okay, what have I said? No, it says submits that the petitioner, that the APDCL will not discontinue the electricity supply to the petitioner. Full stop. I have heard the learned counsel for the parties. As can be seen from the judgment of the Supreme Court in the case of so-and-so Supra, the period of limitation of 2 years. No, wait, not that. The obligation of a consumer to pay electricity charges arises after the bill is issued by the licensee company. The bill sets out the time within which charges are to be paid. And if the consumer fails to pay the charges within the stipulated period, comma, they get carried forward to the next bill as arrears. Subsection 2 of section 56 provides that no sum due from any consumer shall be recoverable under section 56, comma, after the expiry of 2 years from the date when the sum first became due. When the sum became first due. When the sum became first due. Invert comma, the first due. Comma, unless such sum was shown continuously recoverable as arrears of charges for the electricity supply, nor would the licensee company disconnect the electricity supply of the consumer. Okay, you got it? First one. Where is the clarification on first due?
Yes, clarification of first due allotment will get at para 6.9.
Huh. Para 6.9 of the above judgment of the Supreme Court judgment in Rahmatullah Khan Supra states that the liability to pay arises on the consumption of electricity. First up, the obligation to pay would arise when the bill is issued by the licensing company, comma, quantifying the charges to be paid. First up, electricity charges would become, inverted commas, first due only after the bill is issued to the consumer, even though the liability to pay may arise on the consumption of electricity. Next, section 56 of the Electricity Act 2003 states as follows. I take it down. Next. Section 7.5, para 7.5 of the judgment of the Supreme Court in Rahmatullah Khan states as follows. Right? You take it 7.5 and you take 8 also. 7.5, 8 and 8. Huh? Eight, 9.1, 9.2. Next para. In the present case, the APDCL had apparently charged the petitioner electricity by using the multiplier factor of 1 and had realized their mistake only in the year 2014. As such, the supplementary demand had been made by way of the impugned letter dated 22/11/14 and the consequential bill, electricity bill dated 21/11/14 by charging the petitioner electricity for consumption as an industrial unit by using the multiplier factor of 50%. Thus, by applying the decision of the Supreme Court in Rahmatullah Khan Supra, it is clear that the petitioner, that the APDCL was not precluded from raising a supplementary demand after the expiry of the limitation period under section 56(2), as it was a bona fide error. It only barred the petitioner, but the APDCL from disconnection of the electricity supply to the petitioner for recovery of the additional demand. First, the period of limitation having commenced from the date on which the impugned letter and bill dated 22/11/2014 having commenced from the date the same was issued to the petitioner, and as the petitioner's writ petition had been filed only on 25/5/2015, there is nothing to show that the payment of the electricity charges is barred under section 56(2) of the Electricity Act. In view of the reasons stated above, the petitioners would have to pay the electricity charges as indicated in the supplementary demand dated 21/11/2014, which should be done within a period of 1 month from the date of receipt of a certified copy of this order. Or make it 2 months. 2 months, 2 months. The APDSL is, however, directed not to disconnect the electricity supply given to the petition.
For recovery of this.
For recovery of the electricity dues as provided in the supplementary demand dated. Rate petitions accordingly disposed of. That we do that other matter. Pending. What other matter is there? 14? 14. Yes, what is this 14?
This is filed by the management of Bata against the award passed by the Labarco. And Labarco reinstated me in charge.
Okay, not here. There's not here. So we'll adjourn the matter. No one appears for the petition on call. According, while Mr. PP Datta appears for the respondent. Number?
So let's remember.
For the respondent. Accordingly, leave this matter after 4 weeks. No stay, no? No stay.
I'm so sorry.
No problem.
Normally, I do not do losses.
Doesn't matter. No harm caused to anybody.
So, Lordship, what I'm on, Lordship, is,
Why is this? Why is this here?
of my writ petition.
Not defined, not throw it away. Just a minute. Just a minute. Yes.
So,
You were under you were talking about the CBC guidelines.
CBC guideline, that is
Then
the last page, at Annexure 15, page 94.
Yes.
That paragraph 3, as per the existing guidelines, single tender can only be accepted subject to recording the equal justification. Lordship, even a single tender. Then at page 95, 4E, second and subsequent invitation of bid tender. As like
4D.
E, I'm sorry, C. I'm sorry, C, not D.
Yes.
So is state may, in the fifth line, the state may accept single tender in second or subsequent invitation call, keeping in view of the guideline of the CBC. So it is very specific law. So in the first is, they said that the, you don't go for some better way and all that. Now CBC is very clear. If there is a second tender and there is again 2% is there, one is financially not qualified or the technically not qualified, then the state may accept the single tender in the second or subsequent invitation.
So it's may. The word used is may.
Yes. So all things are may. In the CBC lawsuit, there's nothing like that. Yeah, but normally lawsuit in the tender CBC conditions are followed. That's why lawsuit. It is all me. So I will not say it's sad. It is all me. So that is the CBC circular. Now, Lordship, this is my writ petition, and Lordship at page 68, because I will go to the other thing. Lordship, I will only show the page 68, because that is the last my note. Page 68. After scrutiny, all the bidders, as stated above, were found to be technically qualified. As the tender was called for the third time, the committee member have decided to open the financial bid on 20/2/24 at 2 p.m. That is the last decision. That is the last minutes.
All bidders means two.
Two bidders. Two bidders. Because the only once lawsuit there were 4 bidders. Second time.
And so the bids were open and nothing. Who was the higher bidder? The higher bidder.
Because here is not the higher person, lowest bidder.
Huh?
L1 person.
L1, lowest.
Because the dietary item I have to supply it also part 56 to 80. So this is, I'm here, Lordship. Then after this decision, suddenly Lordship on 8/3/24, they have come for a fourth tender of the same price. So I'm surprising that the why they go for the year, then I finally repeat. And this court has passed an interim order that we cannot stop. Then Lordship, we come to the affidavit filed by the government, that is the respondent number 4. Respondent number 4 filed the affidavit, that is at page 97, it started. Lordship. Respondent number 4.
Yes.
And Lordship come to page 99, paragraph 4. Paragraph 4, page 99.
Yes.
Sub-para of the paragraph 4. The
Yes.
deponent further begs to submit that only 2 bidders participated after the third bidding. In the first tender bid, 3 bidders participated. However, in the second time, 4 bidders participated. And in the third time, 2 bidders participated. Further, the government of Assam, filed its office memorandum dated, the date was not in the year, affidavit lordship. Dated January 2024, in number so and so, made it mandatory for the JAM for all procuring entity for the procurement of all goods and service that available in JAM. That is available in JAM. That is the word used in the affidavit, because JAM versus lordship knows that there are so many formalities lordship, the JAM person. That I'll go lordship one by one. So that is here, and lordship the para 6. That they have annexed as an annexer A to the affidavit, that notification. That with regard to this statement, in paragraph 5 of the deponent beg to submit that as per the minutes of the tender bid opening meeting held on 26/10/23, it has been held that only one technical document of bidder was found to be qualified, as no comparison of grade could be made. It was suggested for retender.
That is with regard to the third one. Or fourth one.
Third one.
But now, third one, the all tenderers were, were recommended.
Yeah, recommended, subsequently cancelled, that is why they.
No. You see, what I'm saying is.
No, it is not the third lawsuit, it is second.
Second.
It is second lawsuit. It is second. Because the third is 12 to 24 lawsuit.
Correct, that's why. This second, no?
It is second lawsuit. Why am I? It is second lawsuit. No, I not that. Yes, written here, so I forgot. It is a, because the page 68 and page 65 is 12 to 24. And lawsuit the then lawsuit the para 7, they have taken a stand that the paragraph 6 of the repeat report beg to state that the amendment made by the petitioner further beg to submit that the clause 14K, which provides for a butcher original technical catalog and all the I am not ordered. Then the paragraph 9. Paragraph 9 at page 101. That with regard to the statement made in paragraph 14 of the writ, deponent beg to state and deny the amendment made by the petitioner that the further beg to submit that no illegal and arbitrary manner has been acted upon. As per the government notification number ECG so and so, dated January 2024, JAM is mandatory. As such, a fresh tender was invited through government e-marketplace JAM. Now, para 11. There is a sub-para in the para 11 at page 102.
Yes.
That further deponent beg to submit that the first bid only one party qualified, which is not acceptable according to them. In the second instance, it was rejected as no bidders qualified. And in the third instance, only 2 bidders qualified. That JAM is mandatory and the participation in more bidders is required. That is their old ground. Cancellation. It is by affidavit, though it is not there. Then now there is an office memorandum. They have annexed at page 105, annexer A.
Yes.
PCF number 2327632 is put. It is not there, January 2024. That is not there. Office member. Then the notification number and all that they say. Then lawsuit for procurement of goods and service. 1. Government e-market case JAM is mandatory for all procuring entities for the procurement of all goods and service that are available in JAM as per Rule 24(1)(2) Roman 4 of Assam Public Procurement Rule 2020. Lordship will take note of this because I have to argue, the whole argument is based on this one. Because Lordship has the, not there, Lordship has the. Sani ki quote. This is the book, Lordship, Assam Public Procurement Rules 2020. I'll go to that, Lordship. Lordship will keep the book, not now. Now,
This one is 2020, this one is 23. Oh, what? Okay, no. Okay, Mr. King over his book.
Postal. Now, all the books are by Postal. And good, he is doing very well, Lordship. He is good.
Works are there.
Yeah, he's good, he's good. Because earlier it was very difficult. So
Yeah,
something is here, something is there, like that. And his books are good now. Now he's doing very good. Okay. Editorial thing.
Very good.
Edit only, nothing, but he's doing it very. I'll go to that, Lordship. Before that, Lordship, may please come to the order dated 18/3/2025 of the court's order, Lordship, orders.
Eighteen-three.
18/3/2025.
Yeah.
Mr. D. Were learner standing counsel, Health and Family Welfare Department, please for some time to produce the original record in which the decision to go for the retender in JAM was taken. So accordingly, my lord, subsequently, I have given a copy in the open court, Lord. So this is the
parts I have given, otherwise these are original. Final.
So my learned friend has given me this, and this is original record has been. So this is the page 11 also. All the, because I have given all the minors. Lordship, please come. Page 11.
Page 11, yes.
Minutes of the tender financial opening meeting held on 22/24 at 2 p.m. in the conference hall. So it is 22/24 at 2 p.m. There is a meeting. Lordship. And all this person they said, and the down below after the name, since there were only 2 bidders participating in the process to have a better participation and involvement of more numbers of bidders to ensure the quality, the committee members would like to recommend the principal superintendent, superintendent and the superintendent MCS, Dibrugarh, to float a fresh tender to Zempur. So this they have given now after this court. So whatever. Now, Lordship D, now this is the decision to go for Zempur. By on 20/22/24 at 2 p.m. when it was fixed for opening the financial. Only thing, Lordship, in their affidavit, Lordship will not get a whisper that financial bid was open. Then my client there are so many members and he's doing business there only. So they said, no, I know your financial bid is clean. How come you come to know about it? No, we have opened it. That is how he came. Then I argued. Then I informed the court. No, my lord, the financial bid is open. So to that effect, I filed an affidavit. In the reply, it is started at page 103. Oh, sorry.
2 minutes.
Yeah, sure. Now let's see in the, against this affidavit lawsuit of the government filed by the respondent number 4. This two thing is missing. One is that there was a minute dated 22-24. That is not good. And this was not an today here. Second thing is not there in the affidavit that they have opened the financial. They are
Yes.
silent about that. They have only said that they were annexed a memorandum, office memorandum, and they say because of this office memorandum, they have gone for the fourth time.
Yes.
So the India affidavit, they have annexed only one document, that is the office memo. However, before this affidavit was filed on, Lordship will take note of the date in the month of August of 2024. I don't know this date.
13th August.
Lordship,
13th August.
13th August. So Lordship, 13th August, they filed this affidavit before this court, but they are silent about the minutes dated 20-2024. That is my one link argument. They have not mentioned that there is a meeting on 20-24 wherein this decision to go for the exam as per this notification office memorandum we have annexed, they have taken. They have not
Office memorandum dated
office memorandum dated January 2024, the date is not there in the office memorandum, but in the signature part, the date is there is 8/1/2024. In the office memorandum, date is not there. In the signed document, it is signed. In the signature, it is. Lordship will, otherwise Lordship will not get the date. Because in the affidavit also they are not sure. And I do not know, Lordship, for a moment come with that. My learned friend will clarify. It pays 107 for a moment of the government affidavit. I do not know what is this. Because that I cannot clarify my learned friend. Pays 107 in the top is the commission and secretary signed. It is 8/1/24. But now this is a digital document also. We have also, taken a copy from their website. In the down below, it pays 107. Digitally signed by so and so, dated 22/2/24. Time is mentioned. I do not know what is this. The location, Assam, and here. And she is the Undersecretary or the Deputy Secretary of the Finance Department. Because if we have to go by this date, we have to go by this date because this is digital signature. And interestingly, in the memorandum, Lordship will not get this type of memorandum from Government of Assam. In the first page 105, date is not there. Had this been there, then Lordship may please come to page 11 of this bunch of paper I have given my learned. Page 11. This is of 20th of February. And here they have not mentioned anything about this notification, about this office number. There is nothing in this decision.
No, but this is 22. Acha, but signature 8/1.
Oh, it's 20. That is why, Lordship, if it is 22, then lordship,
That's okay.
then it is okay, because they cannot refer to that. But if it is 8-1,
Then this should have already been there.
yes. So by this affidavit, they are going hotel. I do not know which one is correct. But there is, I do not know, my lord. Maybe if it is the 8-1, then this should have reflected that. That there is an office memorandum dated 8-1-2024. So in view of that office memorandum, we are taking this decision. And in the affidavit, nowhere it is mentioned that on 22-24, they have taken a decision because of this. In the affidavit they mentioned, but in the decision there is nothing. There is a missing line. I do not know, my lord. That my learned friend will clarify. I know. Because he has taken this. Now, let's see, we have given a reply to their affidavit. That is at page 108. And I'll not read the whole reply, but two things. At paragraph 3, I have taken that point, paragraph 3.
110.
110, yes, got it.
Yes.
That the bare reading of the statement made in the said affidavit, the respondent number 4 did not specifically controvert the statement made in the writ petition and also did not answer the point of substance except the plea that the government of Assam by this office memorandum dated nil January 2024 CF number made it mandatory for them for all procuring entities for procurement of all goods and services that are available in JAM. The said office memorandum has been annexed as an annexer A to the said affidavit. Therefore, the deponent reiterated and reaffirmed the statement made in the writ petition against the statement made in the said affidavit filed by the respondent number 4. Now in the paragraph 4, I have taken that one, what I have argued now. A bare perusal of the said office memorandum dated January 2024 number 4 would reveal this same was signed on 8-1-24 by the Commissioner and Secretary Government of Assam, Finance Department, and it shall come into force with the immediate effect. The said office memorandum was digitally signed by Sanghamitra Bhagavati on 24-2-2022 as reflected therein. Means 22nd of February 2024. It is digitally signed, lordship, so it is like that only. The said office memorandum does not have retrospective effect, as such have no application in the facts and situation of the present case. So if it is this 22-24 and the office memorandum, the last line is very correct, lordship. Office memorandum last line at page 107, this cell came into force with immediate effect. Even today, lordship will click the A, lordship will get this signature and it is there in their website. That it is digitally signed and it is digitally signed on 22nd of February 2024. So it is the last line at page 107 that this cell came into force with immediate effect. Page 107. So that is my affidavit. Then the third point in my reply is I have given at page 111. Line about 10 from the bottom. The respondent number 4 and 5,
Yes,
10 from the bottom. The respondent number 4 and 5, in most illegal and arbitrary manner, invited a first tender through JAM with a malafide intention to deprive the petitioner from awarding the contract, in as much as the deponent came to know from the reliable source that 2 out of the 3 members of the tender committee surreptitiously opened the financial bid of the petitioner and the pro forma respondent number 4, and it was found that the petitioner is the lowest L1 bidder. That on oath I have stated. Then what happened? Because I have stated this on oath, the court said, all right, you bring the record. that I have shown in the morning itself, Lordship. The court said that whether you have opened the year, so that is the document, Lordship, that they have opened. Today morning I have given. If Lordship affidavit necessary, Lordship will reserve the journal, I'll file that affidavit. That we have given it. So when my learned friend has the same document, so I have no problem at least. He has shown that the same document here. So it is very clear from that document, Lordship, that it was opened on 20/2/2024. The date fixed for the opening of the financial bid. And when they have opened it, and look at that, I'm the L1. Because they from the day one, they are not with me. So they do not want to give it to my client. So they said, let's go for the fourth tender. So there the arbitrariness and all this unfair and everything will come into this, Lordship. And this document clearly shows, because this has nothing to do with this handwritten office note and here. Once you click that, this thing will come. And the rule is very interesting, Lordship. I have never seen this. Lordship, for the first time I have seen yesterday that Lordship, when Lordship will get this, otherwise Lordship will not get this. I have for the first time I have seen, I have never seen this. For Lordship's convenience, I have seen this yesterday night. Because I thought, where from this thought has come? How come? How might, because I had a back of mind that where from my client, how my client is getting that they have opened. Lordship, this is a handbook on the Assam State e-procurement portal. This is the handbook. Lordship, here, Lordship, please come to page 17.
Yes.
Page 17, Lordship, in the procedure for financial opening and financial evolution. Top, Lordship, get it? The financial opening, the department who uses the bid opener role can only open the bid as he has decrypted the bid by his or her digital certificate. Only then, no one else can open. Now, then 2, all these bullet point, Lordship, from down, 1, 2, 3, from down. Yes. The financial bid document can be downloaded after at least 2 successful decryption, as in our case also. 2% is open and 2 dot only. The third person is not open. There is 3 members for opening the financial bid. And that is why that dot has come. The financial bid document can be downloaded after at least 2 successfully decrypted. Otherwise, we can download that document also. Then, after successful review of the 2 bid opener, a folder appear automatically. Click on that folder. Lordship, only yesterday night I came to know about it because online I am very poor. They have helped me with all this. So, this is opening of financial bid, Lordship, and this is their own document for e-procurement portal of Assam government. And that is how this opening of financial bid has come. So they have seen my financial bid. So this is somehow I do not know if the day one this petition will move before. And that is the order dated 27/3/2024. It's an 11 of them. Lordship has written it very, it's a long order, Lordship. Lordship has written everything. What is how to jam portal and all that. It is there. Now, Lordship, before I go to the rule, now one point I want to clarify to your Lordship. Now, in the affidavit of the government, they have taken a stand that because there is an office memorandum, whatever we did, so immediate effect is the year that the all government tender. You have to go understand. At least this is an affidavit from the health department. And though it is for this office memorandum is for the state of Assam. It is from the finance department of state of Assam. That now onward, 8/1/24 or 22/2/24, whichever is the day. After that, one have to go by the office memo. So Lordship may please come to 130. Lordship, sorry, I'm sorry.
Yes.
130.
Yes, yes.
So this is an additional affidavit filed on behalf of the petition. Here, Lordship, in the paragraph 4, I have said, then paragraph 5, Lordship,
Yes.
page 115. The subsequent to filing of the affidavit in question by the respondent number 2, the petitioner has come across and collect some e-procurement tender details and tender notice, and the tender to invited to the e-procurement system by Government of Assam, which are as follows. I given a list. It's a long list, Lordship. And I have annexed it as a annexes 16 con. Now, Lordship, the annexes, it is started at page 121.
Yes.
Lordship will see the date on the top, 25th March 2024.
Yes.
Then organization saying Health and Family Welfare Department, Assam Medical Service Corporation Limited, with the health department, under the health department. Then the item to be here. This is not under SAM. Then the next one, 25th March 2024 at 11:36. Again, the organization is Health and Family Welfare Department, Medical Education, so-and-so, FFA Medical College and Hospital, Borpeta. It's a medical college. Like in petitioner's case, Lordship, it is a Assam Medical College. It is Borpeta Medical College. So this is after the notification. So Lordship, now work description. There is work description and all that. Lordship is there. Lordship will look into that document. Work description is computer and accessories. Then
Where?
in the middle of that
Page.
document, 122. 122 page. Left-hand column, Lordship. There is a bold here, work items.
Work item. Yes, work item.
The title, computer and
Okay.
accessories.
Ah.
Work description,
Yeah.
computer and accessories standard. Contract type is rat contract. Rat contract means it's a open competitive bidding. Because the only thing, the ZAM is an exception to open competitive bidding. It's a rat.
It's a rate contract. DGSD rate contract basis.
Yes. Yes.
So, but then it is also part of an auction system. There's a lot of companies that are listed under the DGSD.
DGST they have.
No. So this gem, the companies who are listed under GEM, they are listed under the DGST, Director General of Supplies. It's under that. I think it's a department under the Ministry of Commerce.
Rat contract, that concept is not. Yes, ZAM and DGST rat.
No, DGSND, and they've got their rates and there are number of companies who are supplying the same thing also.
That's in ZAM.
I think, yeah.
That's in ZAM.
Huh.
Yes, that's true. Yes, yes.
But to be in GEM, to be in GEM, I think maybe you have to register with the DGSND.
Yes, sir. That I'll show, from the, there's a long procedure. There's a long procedure, Lordship, not like this.
Product will have to be registered.
Huh?
That product will have to be registered.
Yes.
So it is, that it is not there, I'll show. I'm sorry, I am also not conversant like that, Lordship. So don't like me. So I have to read, I have to get my learning pen, they're showing me on. So I am not first, I'm helping a Lordship. Some Lordship knows the thing, Lordship, so Lordship.
No, I don't know. I know the bits and pieces here and there.
But at least Lordship, that much Lordship, no details, and they have their red contract and board that there is a registration, registered item, they have the fixed that and all that. It is there because in the arbitration, Lordship, I still remember, Lordship, that Lordship has appointed the arbitrator that we there. That matter litigated case asked me and Sarah, Dr. Sarah, he was at the side. And BP Kotokia started asking us all this. That no, this is government of Mizoram contract. Where from you get this? What is this? And you show me the book. No. Today morning I have seen in the item number 3, Lordship said, you're saying you're not true. You have to show it from the law, from a book, from a dictionary. So I have at least sitting here today, I saw this is an equity for 226. I have seen that. And the both the Lokhimpur case also, Lordship, it's so much. So I am happy at least to that effect. Lordship is clear in mind, Lordship, that hearing both the side, dispose of the matter. It is good, Lordship. That, so all this page 123 again, these are all health department, Lordship. That's my point.
Your case is, the only reason they have given it to GEM is because of the OM. If that be so, why not these cases, these 10?
Secondly, why you have opened my financial? Why after the opening of the financial pit, you have decided to go for a court payment, which you cannot. Because once you know my RAT, you tell the other that he has given this RAT. Next time you give below that. You can open my deed in an online tender. If you do not want to open the financial bid, that's a different matter. Now you open the financial bid, then when you see that my client is L1, you are going for a court tender. And without assigning any reason. Now affidavit, they are saying all that there is an office memorandum and all that. But in the minus, this is not there. They have not referred to any office memorandum. They do not know even on that day. From their decision, their office note, nothing.
How much more time will you take?
Lordship, because I have to go to the rule and I have to take at least minimum.
Minimum how much?
Half an hour. Half an hour.
Because I've got a meeting at 4:45.
Lordship, any day convenient to my.
No, convenient to the honorable.
No, the thing is that I don't know, because tomorrow too I've got a tribunal.
Yes,
I'm
the
heading a
second half
tribunal
also.
tomorrow, second half. No
There
time.
13 or 15,
Huh?
13 Lordship is already preoccupied. Not
15,
15, but
13, I have 2 meters left.
15.
15 also, we have 15, I don't know. Niganku will know.
Perfect.
Because he knows what we have put.
Or 28 months. Yes, he was fixed, I think. They complete the service
Huh?
on 20th.
What have you fixed?
So item 6, madam, today's this. It will come
Hearing?
20th. Hearing. Admission vote.
Huh?
It can take-
We've already fixed item 6.
Let it be on 20th in that. I think because only small part here, my lord, issue is very short, my lord, whether we can cancel it or not, my lord, pursuant to that notification of OM of the finance department of 8/1/20. There is a whole issue. On that ground, that's the ground only, my lord.
No, but then he has also raised, see, he has put in You see, the OM, first of all. Now the OM, first of all, there's no date.
There is eight one, madam. That I can prove, madam. In fact, just now, my colleague, checked it in the website. This is the copy uploaded in the website, madam. That digital signature is not there. This is the copy actually. Probably while printing,
They are in
so
Excel.
that's why while printing, that has
But-
come up.
but
this is the
where-
copy. So it's there
No.
in the website.
No, but this is the same thing that he
Same
has
thing.
also.
The
No,
digital part is not there, madam. That's
no, but how come there's no 8-1, the
No,
first,
but madam, he has signed
January?
it, madam. The sign is there. It's not that for
You
this.
see, OM I've seen, I think in your entire career as a lawyer,
No, I can have a clarification from the finance department. I can bring the original one if required.
you have to bring the original one.
Yes, I will bring it. I can. Because it is uploaded, this particular document, just
No,
now
you
the-
see, is it gazetted?
No. No,
That I will check.
no.
Yes, I will have, I will clarify everything from that
It
point.
has to be gazetted, then only it will come into effect. And satisfy your lordship that. is there.
You see, another thing, pertinent point. Now, you have taken a stand that because of this OM,
Well,
it should go before jail. I mean, that should be done. I think.
Yes, sir.
However, what about the other tenders that you have issued subsequent to that?
So, madam, here is the issue, my lord, so far as the tendering authority is concerned, it's a particular medical policy. And a reason I will place, madam, of this additional affidavit document, that I will place, madam. Why, madam, it is not in JAM or in the e-portal of the government, not in JAM. That I can place, madam. Well, very short reply will be, madam, that has been pointed out by my learned senior, that, madam, these are all rate contracts. Rate contracts are not there in JAM. I will place the written instruction of contract. Rate contracts are not there. But rate contract is something, my lord, they will fix the rate. And on need basis, my lord, say for 2 years, the tender is valid. Within these 2 years, my lord, they will seek for, my lord, various medicines and all. And that will be supplied. Rate contract. That's why, my lord, the tender, mode of tender is rate contract. That I have already marked, my lord, it's rate contract.
Which one is, this is a rate contract?
No, so far as, my lord, the
This other.
others are concerned. They are rate contract. That's what they've said. That's what I message over. Yes, yes. They are- Because they have tried, my lord, they could not, that's why, my lord, in fact. These
Correct.
standards were plotted in, my lord, time. Third time. And also we see the date, my lord, on 9/1 the tender was plotted. This, my lord, OM, if we say, my lord, it agrees or it is effective, it came on 8/1. So 9/1 the tender was plotted, the third one. That the date I will place, is there in the report. Is there another disputed issue? 9/1 the tender.
Decision to go for the 22, 24.
That the court will decide, my lord, but the ground is there, because the OM came on 8/1, tender was plotted on 9. It was not within their knowledge, so they finally.
So, my lord, see, for my problem.
And now, my lord, the issue is not that, my lord, only JAM. They have stated that for a better rate, you must go for JAM. That's the line, my lord, in the 20th of February, 2024, finance.
No, no, no,
Not
no,
that
no,
one.
I'm let me clear only one point of. Here, tender, lordship, for a moment, my learned friend.
No, that-
I do not
that's-
know, either I am wrong or the 9/1, this is 22, 24, here is there, that they will open the. Here, fix a date, that they will open the financial meeting. On that day, there is a meeting. And on that day, they said that they will go for a test tender in the Jan. So it is before that, lordship. 22, 24 itself, they say. And
Okay, all right. Heard Mr. S. Sharma. Then the senior counsel. And Mr. B. Gogoi. Addition. Mr. Gogoi, you are the addition lady.
yes, sir.
Addition lady. Assam. The petitioner's counsel submit that in terms of the CVC guideline, the petitioner's bid could not have been ignored on flimsy ground. He submits that the petitioner's bid had been opened. He submits that the bids of the two valid bidders had been opened. And as such, the selection of the successful bidder should have been taken to its logical conclusion. In terms of circular number, what is this? Non-circular number. Page 94.
Lordship,
In terms of clause 4 bracket C of the circular number blank slash 2013 dated 15/1/2013 issued by the National Rural Roads Development Agency from a Ministry of Rural Roads Development, Government of India. Yes. He also submits that when the tender committee in its meeting minutes dated 12/2/2024 had taken a decision that the financial bids would be opened on 20/02/2024 after having found the bids of the two tenderers to be technically qualified. They could not have subsequently taken a decision to float a fresh tender through the GEM portal in the tender committee's meeting minutes dated 20/02/2020. He also submits that the affidavit of the respondent number 4, which had been filed, respondent number 4, which had been filed on 13 August 2024, is silent on the fact that the bids of the petitioner had been opened on 20/2/2024. And the financial bid of the petition had been opened on 20/2/2024. It is also silent on the meeting minutes dated 26/10/2023. 2610, 20. No, not 2610. No, on the meeting Monday 20/02/2024. He also submits that while the respondents have taken a decision to float a gem tender in respect of the petitioner's case. In respect of the petitioner's in respect of the present case, the health department has not taken any decision, has not gone for gem tender in respect of other tender works, in respect of other supply works pursuant to 2024. Yes, sir. Next, due to paucity of time, no, next. List the matter. Due to paucity of time, the matter is adjourned. Till? 20 March. Anything there? No. 20 March. Okay, in the meantime, the petitioner may file an additional affidavit. I've got so many matters, I don't give it matters. I'll tell you. Interim order to continue till the meeting. I don't know, you can return order. You get that.
My lord. My sincere apology, my lord. My lord, I want to listing a matter on tomorrow, my lord.
You want to?
Listing a matter, WPC on tomorrow, my lord.
What is the matter about?
My lord, by petition is the mining contract of my lord. Is the contract area and work as seized without any notice. So this area and the work as seized, my lord. And the payment option was also disabled. And hence he could not work in this area, mining area. If possible on tomorrow, my lord.
He could not work? When?
His work has been seized, my lord.
His work has been seized?
Yes, ma'am.
His work has been stopped, you mean?
Yes.
By when?
By DFO, my lord, on 29th of March, my lord. And
29th of March.
And his payment option was disabled on
29th of March, and you're coming now in May.
No, my lord, actually, my lord, his payment option was disabled, my lord. That's the problem, my lord.
His payment option was disabled.
Disabled, yes, sir. He will be automatically defaulter, my lord.
If it is stopped, why was it stopped?
Yes, sir.
Why was it stopped?
Yes, well.
Yes, but yes, I'm asking a question.
Without any notice. I filed a representation before the assistant conservator of forest.
When?
In my lord.
Sit down, sit down.
On my lord, 1st of April, my lord. We filed a representation before the divisional forest officer, my lord.
And you're suddenly in a hurry today.
No, my actual payment option was stopped, my lord.
Payment option was stopped when?
When 1st of May, my
First
lord.
of May.
Yes, my lord.
And today is?
Today 8, my lord. After my lord, 7 days, my lord, you will have to clear my lord 15% of interest, my lord.
So you want to pay the amount?
Yes, my lord.
What do you want to pay?
Yes, yes, sir. But payment option was disabled. Online payment option was disabled.
But your work has stopped, so there's
Yes,
no requirement of paying.
But this is one aspect, my lord. My work is.
You are a defaulter, that's why it was stopped.
My allegation against me is that I'm extracting sand beyond my allotted area.
Area.
Yes, sir. But without any notice, my lord, my friend and my workplace was seized, my lord. And as well as my payment option was also, my lord, disabled.
Have you given a copy to the other side? Have you filed it? Have you filed it? Have you filed your petition?
Yes, yes, well, this was numbered on,
Huh?
already numbered, my lord.
What is the number?
2454.
Check if it is already numbered, let it come.
Obliged, lord.
Where is the mention
Yes,
memo?
yes, I have the. Much obliged, lord.